Hello.
Hello.
Do we have a court reporter here and ready to go?
Good afternoon, I'm ready.
Excellent, thank you so much. Anything we need to deal with before we go on the record? Mr. Tate.
Madam Chair, I think my issue needs to be done on the record. It's a preliminary matter, so I'll wait a moment.
Okay. Anything additional before we go on the record? Mr. Smith.
I'm the same way, Commissioner. I'll wait until we go
Okay.
on the record.
Okay.
Commissioner, I think I have something we can do off the record.
Uh-huh.
UCA, just as a heads up, UCA will be waiving cross-examination of Mr. Weinberg and Mr. Jensen.
Okay, got it. Thank you for that.
And Commissioner, if we're going to do waivers now, which is fine, I didn't know if we wanted to wait until that was on the record. That was staff's issue that we were going to raise. Would you like to do that now or wait?
I'm going to answer that question. Maybe we'll just go on the record and we'll get it there, just in case. What's
works
the
for
worst
us.
that can happen? She'll write it down for us. Thank you. All right. So, Ms. Crampton, I have you UCA waiving Weinberg and Jensen.
That's correct. Thank you.
Got it. Mr. Smith, go ahead with your waivers.
Sure. I believe yesterday we indicated that staff was going to reserve 15 minutes on company witness Quillian. We are going to waive that time. We don't believe it's necessary. And in addition, we will be waiving staff's intended cross of CEO witness Hay. And we will be reducing our time on sweep witness Brandt to 15 minutes.
Almost there. Got it. I've got you. Thank you, Mr.
Thank
Smith.
you.
Appreciate it. Mr. Tate, something along these lines?
Oh, Madam Chair, something slightly different. Just wanted to advise that during the hearing yesterday, staff advised me that Project Canary Exhibit 1007 that was admitted into evidence was not properly marked. I've worked with staff and corrected that. And the corrected version of Exhibit 1007 is in the Project Canary box and can be now inserted into the record.
Excellent. And I recall yesterday there were no objections. So essentially we were planning on getting it in contingent
That's
upon
correct.
that little formatting change for you. So I presume no objections still. So we will admit it in its revised version. Thank you, Mr. Tate.
Thank you, Madam Chair.
Ms. Kutzer.
Thank you, Madam Chair. I have reserved 15 minutes for Mr. Weinberg. I may need a little bit more time, and so COSA is asking to swap time from Mr. Gardner. I have 30 minutes reserved for him. I'd like to take 15 of those minutes, apply it to Mr. Weinberg. May also be able to waive Mr. Gardner, and I can correspond with the company offline about that, if that's acceptable to you.
Sure. So for now, I'll get you at 30 total on Weinberg and 15 on Gardner for now.
Correct. Thank you so much.
Yeah, got it. Mr. Gonin.
Thank you, Commissioner Gilman. Sweep will be waiving its cross-examination of Mr. Weinberg.
Afternoon's changing fast. Okay. Anything else, Mr. Gonin?
Nothing else from me.
Okay. Anything else, Mr. Larson?
Thank you, Madam Chair. Yesterday, during the redirect examination of Mr. Oz, there was a hearing exhibit put forward, hearing exhibit 129. That was not admitted into evidence pending a conferral with the parties. We have conducted that conferral. I'm authorized to state that no party has objected to the admission of hearing exhibit 129. So at an appropriate time, we would move its admission.
Okay. Sorry, remind me what's in hearing exhibit 129.
It was the Roadmap 2.0 derivations that Mr. Oz stepped through in terms of the adoption rate for
Okay.
electrification. It was a series of slides.
Yeah, that works. I don't have an exact opinion on if we just do it now. If that works for you, if you've already conferred with the other parties.
Yeah, and it actually should be hearing exhibit 128. My apologies. So we would move its submission.
All right, 128. Any objections? Okay, hearing none, it will be admitted. 128.
That
Thank
was
you.
what we had, Madam Chair.
Okay, that's all you got? Okay, just wanted to talk through real quick what I'm thinking, especially I presume we still have Commissioner Plant on here somewhere. Yeah, he's here.
I'm here.
Commissioner Plant, I wanted to go over with you a proposal for the end of the hearing in this testimony we're talking about regarding the new modeling run. If you're ready, I'm sure I'm catching you real fresh. Okay. So regarding the discussion at the end of the day yesterday regarding the process envisioned for the additional modeling runs that were requested by the Commission Monday, my proposal is essentially that we allow direct, so I think it would happen after I leave. We'd do I leave for any rebuttal to the flex plan, and then we'd go with Oz. Thinking it happens Monday, but we'll see when we get to the end of the hearing. And so we acknowledge that this is a record supplementation order from the commission, and it does not reflect the policy decisions the company decided in making their case. However, for this evidence to be properly weighed by the commission, it's important to hear from other parties on cross. And to that end, I would propose that we allow limited cross-examination following the company's oral direct testimony by Mr. Oss. I would like to warn the parties that we would be vigilant about limiting the scope of this cross to the company's direct testimony regarding the additional model runs, and expect and anticipate the utility cross-examined by the parties in this instance to be on questions regarding the process utilized to perform these modeling runs. That is, the how these exhibits were put together. Parties already had an opportunity to cross-examine the company's modeling witness on the choices they made in putting together the modeling represented in the direct case and rebuttal, and don't expect any additional cross on this to be appropriate during this. Because of the limited scope of the anticipated cross, we limit it to no more than 10 minutes per party, and encourage parties to coordinate and work together to limit the overall time on cross. I think this proposal acknowledges the company's concerns about presenting a witness to provide testimony to ideas it didn't agree with, and the limited time frame for preparation and review, but also acknowledges the commission's need for a fulsome record and the party's interest in adding to that record, just to ensure folks can understand how those additional modeling runs were completed. So that's my thought at this time. Commissioner Plants, any thoughts on that as a process to move forward?
I'd support that.
Okay. So that'll be the plan going into whenever we get to the hearing. Ms. Dundas.
Just a couple of details to clarify there. So that would be direct oral and the limited cross as you described that would occur. It's looking like Monday, but more likely Tuesday at this point with the scheduling. So it would just be at the conclusion of the cross scheduled by the matrix, correct?
I was going to go cross scheduled by the matrix, then I leave for the rebuttal basically on the flex that is allowed given the other party's directs, and then this.
Okay, and then one more clarification, just we've been sort of talking about it as if it's assumed that it's Mr. Eiley that's coming back to do the direct rebuttal on the flex portfolio. I imagine that's probably true, but that's in the company's discretion who they bring back for direct rebuttal.
Correct. Sorry to be presumptive. Yes, a rebuttal witness, since we are allowing that live direct from other parties regarding the flex plan.
And then same on, I again assume it will be Mr. Oss that would be direct for the modeling runs, but that would still also be a decision of the company who they bring back for that.
Thank you. Yeah. You did it better than I did. Thank you. Okay. So with those clarifications, we were with Mr. Weinberg yesterday. We just had some testimony get waived here. So we are up to COSA. No, we did COSA. We are up to commissioners since UCA waived.
Excuse me, Commissioner Gilman, you have not done COSA. I think I'm up.
Okay, sorry. My notes are bad. Okay, so you show you're next.
I do.
We agree on that now. Sorry about that. Okay, I've got you for 30 minutes. That sound right?
That sounds right to me.
Okay, I think I'm back on target here. All right, 30 minutes. Go right ahead.
I don't want to make things any more complicated, Chair Gilman, but I did alert counsel for the company. I will be asking Mr. Weinberg a single question on a highly confidential document. I do believe I can do that in a way without discussing highly confidential information itself or going into a session. I also alerted the legal assistant to this possibility. I'd recommend that we attempt to get through there, and if we can't, then we'll reconvene if that is okay with you.
Yep, and we'll just might have to be flexible about that time frame if we do that. And before we get started, Mr. Weinberg, I just wanted to remind you that you are still under oath, sir.
Yes, Madam Chair. Thank you.
All right, go ahead, Ms. Kutzer.
Thank you, Chair Gilman. Good afternoon, Mr. Weinberg. How are you?
I'm good. Good afternoon, Ms. Kutzer. How are you?
I am doing well. So I'm Ellen Howard Kutzer. I'm an attorney for the Colorado Solar and Storage Association. We haven't met each other, but it's nice to be talking with you today. Couple things to level set. So my questions will be talking about renewable natural gas. If I use the terms recovered methane, renewable natural gas, or biomethane, do we generally understand each other that we're talking about the same category of clean fuels?
Yes, I think generally speaking, we know that coal mine methane is not a renewable source, so it's not RNG, but it is recovered methane. All the other sources are generally the same.
Super. Okay, great. Thank you for level setting with me. So let's start with your background a little bit. So your title is Senior Consultant for Strategic Asset Planning. Is that correct?
Yes, it is.
And so as a part of your job, do you consider the risks and opportunities of acquiring potential new assets for the company?
I don't.
Do you, maybe to put a finer point on it, do you consider, say, environmental risks as one of the considerations when you're looking at acquiring new assets, including recovered methane for the company?
I guess I would just clarify, Ms. Kutzer, that as my role, I'm part of our corporate strategy team, so I look more at high-level strategic initiatives, such as our emission reduction initiative for our gas system, which we call our net zero vision. It's not specifically targeted at assets, acquisitions or asset investments. And I do realize my title might be a little bit misleading, so apologies for that. But it's more high level strategy development that could include, how are we going to reach certain targets? How are we going to reach our vision from a strategic perspective?
Let me ask a more general question. In your opinion, do you think it's important for Excel as a company to consider environmental impacts and environmental justice impacts from its business activities?
Yes, I would say generally speaking, that is definitely part of our strategy.
Okay, great. So I saw in your statement of qualifications that you have significant past experience with both emissions trading and carbon offset programs. Is that correct?
Yes, that's correct.
And as the company's witness on recovered methane, are you generally aware of the regulatory standards for recovered methane across the various states in which Excel operates?
Could you perhaps clarify what standards you're referencing?
Sure, I don't have a specific one in mind, but let's say, are you generally familiar with Regulation 22 in Colorado, which sets forward a regulatory standards for recovered methane here in this state?
Yes, I'm familiar with Regulation 22.
And I'll admit I'm not familiar with like similar regulations in the state of Minnesota, but as part of your job, are you familiar of those regulations?
Yes, when it comes to RNG and recovered methane, I've been involved with, a somewhat similar program called the Natural Gas Innovations Act in Minnesota. That's my general understanding.
So you consider yourself a regional expert on those topics?
As in my role, I specifically look at our service territories. So those cover 8 different states. So I would say those are more my focus than the other states.
Okay.
Makes sense.
That's fair. So I also saw in your statement of qualifications that you've worked with, quote, all leading U.S. carbon offsets programs, as well as the International Clean Development Mechanism. Does that sound familiar?
Yes, that is.
So is it fair to say that you're a national expert on emissions trading regimes in the United States?
I would say somewhat. So there's a lot of different programs out there. There's a lot of information out there, but generally speaking, yes.
Okay. We'll come back to that later. Could I turn back to the record and take a look at your rebuttal testimony?
Sure.
Could we please pull up Hearing Exhibit 121, page 13? And so, Mr. Weinberg, as you're pulling that up too, take a minute if you need to pull the paper record, of course. In this section of your rebuttal testimony, you're generally outlining the changes that have been recommended to the company's recovered methane request in its rebuttal case. Is that correct?
Yes, that's correct.
And here on page 13, line 4, you confirm that the flex portfolio budget for recovered methane has been decreased to $20 million per year in the company's rebuttal case, correct?
Yes, that's correct.
And that's proposed to be a $100 million spend over 5 years. Is that also correct?
Yes, I believe witness Eiley confirmed that previously. I believe that's correct.
Okay, great. So turning now to page 14, you're asked at the top of this page, will the company be able to procure cost-effective recovered methane in volumes sufficient to use that $20 million per year? Could you please read the first line of your answer there?
Yes, based on the RFI results, we believe that there will be sufficient cost-effective recovered methane available to fill, sorry, I'm adding the word to fill that budget allocation.
Okay, great. Thank you for doing that for me. I want to spend a little time on how you're defining cost-effective here in this statement. Mr. Weinberg, have you put forward any direct statements into the record as to how you defined what cost-effective means?
I don't believe I've put forward any statements on how we define cost-effective, but if I'm mistaken, please let me know.
So would cost-effective recovered methane be expressed in terms of units of recovered methane in dollars per MMBTU?
No, in my opinion, cost-effective means in terms of the abatement costs, which is the dollars per metric ton of carbon dioxide equivalent avoided. And that's the unit that we use to compare our clean heat resource alternatives options to one another with. So in order to make that comparison, I think that that's the right unit to make an apples to apples comparison.
So using that unit, has the company put forward a definition of what cost-effective recovered methane is or is not in this proceeding?
I feel like this is maybe more of a modeling question for Mr. Oss. I don't know exactly what the modeling results were, but in terms of what constitutes cost-effective on the abatement cost basis, it would be a matter of comparing those relative abatement costs for the different resources with each other to conclude what is cost-effective.
So I'm not asking about a modeling question with you, Mr. Weinberg. I want to ask about real-world procurement, because at the end of the day, there are dollars and cents at stake here. Has the company determined the level at which they either would or would not pursue a recovered methane project based on cost?
Yes, and the reason why I'm referring to the model is that ultimately it does depend on what the relative abatement cost is, or what the alternative abatement cost is of the alternative resource. So for instance, if we are considering a recovered methane procurement and we have calculated that abatement cost of that procurement, we would need to understand what the alternative is and what the abatement cost is of, let's say, electrification, for instance, and what that marginal abatement cost is of electrification, and to see how that compares to each other. And so that's an exercise that that E3 would be helping us with.
So are you going to be using E3 to help you make individual decisions about whether or not to enter into a contract to procure recovered methane in each and every one of those contracts?
Objection calls for speculation.
Might I respond?
Yes, Ms. Kutzer, sorry, you got me putting the shade up here.
No, that's okay. I understand the working from home. So to respond to Mr. Eisenberg, I don't think this is speculative because Mr. Weinberg has already testified that the only information in the record relates to modeling. And so without anything more specific in the record, I think it's fair to ask if the modeling expert will be involved in those individual contract negotiations.
I think it's relevant overall. Go ahead, Ms. Kutzer.
Do you need me to repeat the question?
Yes, please.
Will you be engaging E3 to determine if the company should enter into each and every one of the recovered methane contracts it plans to negotiate?
I think that a question for E3 would be, what are the abatement costs of the alternatives to recovered methane? And if the model of E3 can tell us what those alternative abatement cost levels are, then we would know what the recovered methane abatement cost level needs to be in order to be cost effective relative to the abatement costs of the alternatives.
So under that approach, if a specific project exceeded the cost that E3 assumed were reasonable in its modeling, would it therefore be too high cost to procure?
Yes, I think that's a fair statement, and it would not be considered cost effective if the model would then say, well, actually, it's more cost effective to select a different resource.
I have to say, Mr. Weinberg, this seems like an incredibly complicated process. Would it not be easier to just set a firm amount by which recovered methane resource is or is not judged to be cost effective?
Objection misstates his testimony. He just said that he's going to use what the model supply stack shows.
Can I reframe the question, Chair Gilman?
Yes.
So if your testimony is that you're going to use what the model says to judge what is and is not cost effective, is it true then if a individual project exceeds those costs, would the company determine it to be not cost effective?
Yes, I think that's a true statement.
And has the company supplied a firm amount at which that point would be reached in this record?
And with amount, do you mean the volume or do you mean a price, as in the abatement cost?
Abatement cost price. Thank you for clarifying.
So if you're referring to the abatement cost, I believe, but again, I would refer to Ms. Witness asked to confirm this, that there is a marginal abatement cost for electrification at which, the model still selects electrification, that being, I believe, in the ballpark mid $400 per metric ton of carbon dioxide equivalent avoided, and that would set that level of where the recovered methane would need to fall under in order for it to be cost effective.
Okay, thank you for that answer. Could we please pull up the public version of Hearing Exhibit 121, attachment EPW7? And while we're doing that, Mr. Weinberg, I asked your counsel to make sure you had the highly confidential version of this document available to you. Do you have that in the room with you?
I'm sorry, I don't know which document. Is that this document that you're
That is
referring
this
to?
document. So the difference would be the price information is filled in.
Yes, I do have that, and apologies. Let me just take a second to reach for the hard copy, if that's
Yeah,
okay.
take your time. No big deal.
Thank you so much.
Mr. Weinberg, if you can let me know when you've got that available, appreciate it.
Apologies, I'm
No
nearly
problem.
there. All right, sorry about that. I've got the hard copy in front of me.
And I'll just caution the witness to just let us step through this slowly. I'd be happy to accommodate trying to do this on the public record so we don't have to do the confidential session, but we'll just proceed with a little bit of caution here.
So, Mr. Weinberg, without identifying any one of these specific projects, do you consider all of these potential resources that responded to the RFA cost effective?
So, Ms. Kutzer, in order to answer that question, we would need to establish the abatement costs for each of these projects. That depends on the price in dollars per MMBTU, and on the other hand, it depends on the emission reduction potential for each project based on the calculations of one of the approved recovered methane protocols. We did ask for that information from the project developers, but we did not receive the emission reduction potential from the developers based on those approved recovered methane protocol calculations. So without those calculations, it's very difficult to establish, what that abatement cost is.
Without that information, is it possible to determine if any of these projects are cost effective?
So as I mentioned in the session yesterday, some of these projects were previously modeled by E3 based on our conversations with the project developers, based on all of the baseline inputs that the project developers provided E3 with. E3 then ran those models or ran those inputs through the approved recovered methane protocol calculations, and they calculated the abatement costs for us. And so for some of these projects, even though the project developers did not provide us with the abatement costs themselves, we did have E3 calculate the abatement costs based on all of the input variables that the project developers provided to us prior to us issuing the RFI. So for some of these projects, I would say that we have a good indication of the abatement costs, even though the developers did not provide us with that information through the RFI.
Do you think a good indication of abatement costs is sufficient for the commission to approve a $100 million investment?
I wouldn't want to discount all the hard work that E3 has done for us. They have developed all of the calculations exactly according to the protocols. They, asked all of the data from the project developers necessary to run those calculations. So I would say that we are fairly confident about those numbers.
Given the lack of information that's clearly available, would the company be open to coming back and seeking specific commission approval of its planned purchase of recovered methane before it actually executes a contract?
I'm not a legal expert myself, so I don't think I know exactly what that process needs to be.
Do you think it would be wise for the company to seek specific commission approval given the uncertainty you've outlined in your testimony today?
Objection, asked and answered beyond the scope of his testimony.
Might I respond?
Go ahead, Ms. Kutzer.
I think this is a key question for the commission to consider, given the magnitude of the expenditure here. I think it's fair for him to answer as to his opinion. And I don't think he provided it in the prior answer.
Overall, I think he can provide his opinion to the extent he has one. Can you maybe restate the question, Ms. Kutzer?
Sure. So given the uncertainty of information on this record, do you think it would be wise for the company to come back and ask the commission for approval of the company's specific recovered methane acquisitions?
So I guess, Ms. Kutzer, my response would be that, we take this very seriously. And by working with a consultant like E3, we want to make sure that we do this right, that we make the right calculations of the abatement costs. Ultimately, when a project wants to be registered as a recovered methane project, it first needs to be registered with one of the relevant carbon offset registries. And that means that those calculations need to then be submitted and needs to be independently verified by an auditor. And those calculations all need to happen. And I do believe that those calculations, there's a checkpoint with an independent auditor on those calculations. And I do feel like we have confidence in that process being accurate. And so if those calculations that will be publicly available determine that the abatement cost of a specific recovered methane project is below the abatement cost of the alternative clean heat resource, then I believe that we've done our work correctly.
Would you report that work back to the commission?
Again, I'm not a legal expert. I don't know how the
Okay,
process
I'll move
works.
on. I'll move on. Thank you. I'd like to keep this exhibit available, but don't need it right now. Actually, I do need it right now. I'm sorry. Sorry about that. So I want to go through a few of these categories here in the response to the RFI to understand them a little bit better.
Sure.
I see here there's a column called feedstock type. Can you explain a little bit more about what that is?
So the feedstock type refers to the resource that the recovered methane will be derived from. And so as we mentioned previously, most of those resources will be the same as for renewable natural gas resources of a biological nature. And those resources can be manure, they can be biosolids within wastewater, they can be food waste, they can be waste from a landfill, for instance. So the feedstock type column refers to what that resource is that the biogas is derived from in order to create the recovered methane.
Can we walk through a little bit of that process? So I understand you're not a technical expert, but as the company's expert on recovered methane, are you generally familiar with how biogases are generated and procured?
I guess generally at a high level.
Okay, so is it fair to say, or do you agree with me that recovered methane is generated through anaerobic digestion of a nitrogen-rich feedstock?
I guess that last part I'm not too familiar with about the nitrogen-rich feedstock. I know that most of these projects will use an anaerobic digestion technology to create the biogas.
You did not grow up in Wisconsin as I did, but subject to check, would you believe me that manure is nitrogen-rich?
I have a lot of trust in you, Ms. Kutzer. I believe you.
Okay, so moving on. So basically what we're going to do is we're going to take an anaerobic digester, place it over the feedstock source, like a manure lagoon, and then through the process of anaerobic digestion, the nitrogen wastes are then converted to methane gas, which is captured, and then there's byproducts. Generally agree with that?
Generally, yes, that sounds correct to me.
Okay. And is one of these byproducts ammonium nitrate?
I have to apologize, but I don't know.
Are you generally familiar with anaerobic digestion producing high levels of ammonia gas, which can be harmful to human health?
I apologize. I'm not familiar with that. I'm sorry.
Okay, well, let's keep moving. So going back to the columns, what does the column MMBTU represent in this table?
So that represents the volume in millions of BTUs, which I believe is a unit for gas.
Why do some of the projects report an MT CO2 per year, CO2e per year, instead of MMBTU in this column?
Yes, it's a really good question, Ms. Kutzer, and it just shows you that some of the developers did not provide us with the volume of the gas inserted, but instead they provided us with what they were expecting to be the emission reductions that they could achieve on an annual basis. So where you see the volumes in metric tons of carbon dioxide equivalent per year, it does not tell us what the equivalent gas volume is. It just tells us what the volume is of the expected emission reductions that the developer is expecting to have available for purchase.
So let me take a step back. MMBTU is the actual gas product that the company would be purchasing and putting into the natural gas lines, correct?
Yes, that's correct.
But what you're saying is this RFI does not necessarily provide the information of the quantity of gas it would be purchasing if it were to sign a contract with these projects, correct?
I guess if you look at some of the projects, like, you know, projects 1 through 5, then you'll see that they provide us with the volumes in MMBTUs per year. Project 6 does. And so for those projects, they did provide us with the gas volumes, and for the other projects, they did not.
When the company makes a contract to purchase traditional gas, does it generally know the quantity of gas it's purchasing?
Objection calls for speculation beyond the scope of his testimony.
I'll
He can
withdraw
answer
that
if he knows.
Okay.
I'm sorry, I'm not part of our gas procurement team, so I'm not quite sure what exactly goes into our gas procurement contracts and what doesn't.
Okay, let's move on. What does bundled and unbundled mean here on the top?
So bundled refers to whether the developer is interested in selling the gas, so what we call the RNG or recovered methane gas, together with the environmental attributes of that gas, which refers to the recovered methane credits. Unbundled means that the developer is interested in selling those environmental attributes or recovered methane credits separate from the gas.
Is the company thinking about purchasing unbundled products and using those in its recovered methane program?
It's something that we are considering, provided that is consistent with the recovered methane regulations, Regulation 22, as you previously referenced.
How would the company be able to make environmental reduction claims if those credits are being used elsewhere?
Sorry, I guess I'm confused. If the credits are being used elsewhere?
So if it's an unbundled product where the environmental attributes are being kept by the developer, is it not, does it not follow that that developer could send those environmental attributes elsewhere to another program?
Yeah, sorry for creating confusion about that. It's the reverse. We would be purchasing the credits, the environmental credits. The developer would be keeping the gas.
I see. Okay, thank you for clarifying that.
Sure.
So what does term mean here in this table?
Term refers to what the developer responded in terms of like the preferred length of the contract to purchase the gas and the attributes.
So many of these are for a contract term that exceeds the time period for this clean heat plan. Do you agree?
Yes, I agree with that.
Okay. And then finally, what does the carbon intensity score mean?
So the carbon intensity score refers to the emission reduction potential for each project. And, you know, as I referenced earlier, that emission reduction potential really needs to be calculated based on one of the approved recovered methane protocols by the CDPHE. The indicative carbon intensity scores that we've received, as far as we know, were not based on one of those approved recovered methane protocols, but in carbon intensity refers to the emission reduction potential.
Were these carbon reduction intensities tied to the corresponding reduction intensities assigned by the California Air Resources Board's low carbon fuel standard?
I'm afraid I can't answer you that question. We asked the developers whether they used one of the approved protocols, and they all confirmed that they had not. And so we don't know exactly what pathway or what calculation they did use. But what we do know is that that carbon intensity score is not based on one of the approved recovered methane protocol calculations.
So is it fair to say then that these projects on the screen cannot be confirmed to be Colorado approved projects at this point in time?
I would say that as I mentioned previously, there were several projects that we had modeled previously with the help of our consultant E3. And for those projects, we confirmed that we know what the emission reduction potential
Let me
is.
stop you right there, Mr. Weinberg.
Sure.
Have
Sorry.
any of these projects been approved under the Regulation 22 protocols? Yes or no?
No,
Okay.
as far as I know.
Okay, great. So in your past experience, are you generally familiar with the California Air Resources Board's low carbon fuel standard?
At a high level, I'm familiar with the market and the program.
Would you agree with me that the low carbon fuel standard program and its incentives have been a significant economic driver for the recovered methane market?
I'm sorry, I don't know if I understand the question. Do you mind running that by me again?
Sure. Is the California low carbon fuel standard a significant economic driver for the development of recovered methane projects?
I think that, as I pointed out in my testimony, the majority of the RNG that's being generated in the United States today is being used in the transportation market, and the California low carbon fuel standard is a large component of that.
Are you familiar with the fact that CARB is considering certain changes to the low carbon fuel standard?
I'm not.
Objection vague, calls for speculation.
Overruled. I don't think he has to speculate if he's aware if they're considering changes.
Yeah, and I answered with a no on that question.
Are you aware that there has been significant controversy about the generation of recovered methane as it relates to environmental justice impacts?
Objection vague, argumentative.
Might I respond?
Sure, Ms. Spitzer.
I think this is an important consideration. It's not present in Mr. Weinberg's testimony, but I think it's a very important consideration as this commission looks at $100 million investment in spurring this marketplace in Colorado. He can answer if he's familiar or not. I don't think it's argumentative to ask if he's aware of this issue.
I agree, overruled. I think he can ask it. He can clearly answer if he's aware. He's the recovered methane witness.
Would you mind, Ms. Kutzer, to just reiterate the question, please?
Are you aware that there's been controversy about the generation of recovered methane in certain areas because of environmental justice impacts?
I'm going to again object on vagueness and assuming facts not in evidence. If there's specific environmental justice impacts that Ms. Kutzer, excuse me, would like to ask about, that's fine. But insinuating that there's some generalized problem in the air, I think is well beyond anything in COSA's testimony or anything else in the record.
Could I briefly respond?
Sure.
I'm establishing the absence of facts in the record, which I think is really important here. This commission has an obligation to consider equity, including environmental justice, under state law. I do intend to raise a foundation with a couple of exhibits yet to be pulled up, but I think that this is a fair line of questioning to ask this witness about. It's a significant issue.
Overruled. I think to the extent he's familiar with concerns in the area, he can answer a question.
So to answer your question, Ms. Kutzer, can I just ask for clarification? These concerns that you reference, are those concerns that are specific to the California low carbon fuel standard market or specific to the Colorado recovered methane market that we're trying to establish within the Clean Heat program?
The existing issues are specific to the California market.
Okay. And so I guess to your question, I would say I'm not familiar with it because it's a different market. So I'm really focused on the recovered methane market in Colorado. It's a different program from the low carbon fuel standard market. I don't know what some of these issues are, but as you previously mentioned, it sounds like the California Air Resources Board is working on fixing those issues. I'm not aware of them.
Is the science of generating recovered methane the same in California and Colorado?
I'm not a scientist. I'm sorry. What is this What science are you referring to?
Is the
The
general
technology.
engineering process of generating recovered methane the same functionally in Colorado and California?
I believe so.
Could we please turn to hearing exhibit 1202 in COSA's box? So to lay a foundation here about some of the questions I've been asking you, this is actually an article that came out today in Canary Media detailing the controversy in California. Do you see that, Mr. Weinberg?
I'm going to object on foundation, hearsay within hearsay, maybe other objections if we see the rest of the document.
Might I respond, Commissioner Gilman?
Go ahead.
I have not moved for the introduction of this document. I've simply brought it up. I think I should be able to lay a foundation here. The witness can answer or not answer. That's his prerogative. But until the exhibits move for introduction, I don't think it's appropriate to object.
I agree. I think the objection is premature here. I think she's attempting to lay the foundation. We'll give her the opportunity to do so.
Ms. Kutzer, what was your question?
Do you see here that this recent article details some of the controversy surrounding the California low carbon fuel standards?
I see the article in front of me, which doesn't mean necessarily that we agree with that, the content of it.
Understanding that the company doesn't agree, do you agree with me that there's been enough controversy that there's media stories about that controversy?
I'm not aware of the controversy or the media stories, as I mentioned previously.
I'd like to take this down for now and pull up hearing exhibit 1203.
Ms. Kutzer, really quick. You'll see from 102 that you've titled it in the header as 1203.
Oh no.
Is it okay? I might be able to fix it. Do you mind if I try and fix it?
Totally fine, Casey. Sorry I messed that up.
No problem.
So Mr. Weinberg, as that's being pulled up, are you aware that one of the central controversies here in California is environmental justice?
Objection asked and answered as to controversies in California. He already answered that question.
So moving on, I'd like to highlight in this document that this is a report from the Environmental Justice Advisory Committee regarding recommended changes to the low carbon fuel standards in California. I'd like to move for for admission of this document, under administrative notice.
Sorry, mute button. Mr. Eisenberg, any objection?
Yeah, I'll object on foundation grounds. It's not been established what this is. It's not been established that Mr. Weinberg, the witness, is familiar with it. Also object on relevance grounds as it relates to different states, some sort of proceeding. I mean, we haven't even seen the full document, so I'm not really sure what the contents are, but I don't think it's proper to either move it in evidence or take administrative notice of it at this time.
So I'd like, if I might respond, Chair Gilman.
Yes.
I'd like to take administrative notice for the very narrow issue as to the fact of the Environmental Justice Advisory Committee's recommendations. I'm happy to either work now or offline with Mr. Eisenberg to authenticate that this was indeed pulled from the California Air Resources Board's website. It accurately reflects that body's opinion. It's a very narrow issue. I'd like to simply introduce it for fact of that specific narrow issue.
Ms. Dundas? Thank you.
Thanks, Commissioner Gilman. I think that it's in your discretion, but I think administrative notice for the limited purpose that Ms. Kutzer laid out is appropriate. Ms. Kutzer can continue to ask Mr. Weinberg about his familiarity with the document. I didn't hear Mr. Eisenberg have concerns about authentication, but if those do exist, we could we can make it a contingent ruling that it comes in until they have alleviated any concerns on authentication, but I don't have any concerns on authentication.
Mr. Weinberg, are the company's concerns on authentication here?
Yeah, I guess we do have a concern as to, I'm not sure what the EJAC is. I don't think it's, so yesterday, for example, Madam Chair, we took administrative notice of a order from the Michigan Public Service Commission, which is a sister PUC to the Colorado PUC. That's fine. This doesn't appear to be a regulatory body or a legislature or other sort of body where we would have a sort of regular order in terms of self-authenticating documents.
Looks to me to be a advisory committee reporting to the California Air Resources Board. Do you have doubts that's the case?
Ms. Kutzer, can you explain if this is a document from a government agency that would be self-authenticating under 902?
Ms. Dundas, I believe it is. This is a subcommittee of the California Air Resources Board, which is an agency of the state of California. While a subcommittee, I do believe this is still considered a document and a report of that specific subcommittee. So I do believe it is self-authenticating.
Okay, Commissioner Gilman, I'd recommend you let Ms. Kutzer continue with her cross of Mr. Weinberg on this document, and pending the resolution of any authentication concerns between the company and Ms. Kutzer, you could allow it in for the purposes of administrative notice Ms. Kutzer laid out.
Okay, I agree. Thank you, Ms. Dundas. Go on, Ms. Kutzer.
If we could scroll down slightly to the fourth whereas.
Yes, and Ms. Kutzer, just so you know, this one has the same issue. The title is 1203, but it's labeled as 1202. Again, do you mind on our break if I can fix it?
Go ahead, Casey, my apologies.
Thank you.
So Mr. Weinberg, do you see here that this document states that this advisory committee has determined that the California low carbon fuel standards has worsened environmental justice issues across the state and nation by increasing entrenched pollutions on the front lines of agribusiness?
Objection. And now we have a hearsay problem. So Ms. Kutzer said that we were going to admit this for the limited purpose of showing that this was the EJAC's report. And she's now trying to introduce evidence from the document of itself, which is a hearsay statement. There's nobody from the EJAC or anyone else in California whom the company can cross-examine on this point.
Might I respond?
Well, I'll just say I don't recall her fact being that this is a report from them, but rather that the report showed environmental justice issues. Unless I heard that wrong previously, Ms. Kutzer. I believe that was the fact.
You did not. That is the fact.
So in that case, I think this is relevant, given this is pretty precisely the fact that she indicated she wanted it for. So go on.
So Mr. Weinberg, to restate, do you see that this body, the Environmental Justice Advisory Committee, has made the finding that the low carbon fuel standards has worsened environmental justice across the state of California?
Ms. Kutzer, I can see the words on the screen, which doesn't necessarily mean that we agree with that conclusion, especially without having seen this report before or without being familiar with its contents.
I understand and accept that qualification. Let's move on from this and talk about the Colorado project specifically. So Mr. Weinberg, back to that RFI, are those the only projects that the company is currently pursuing in Colorado for recovered methane at this time?
So Ms. Kutzer, the projects that are listed in that exhibit, those were the only projects that responded to the RFI. Those aren't the only RNG projects or potential recovered methane projects that are available within the state of Colorado. We do have regular conversations with project developers who are interested in interconnecting their projects to our gas system, some of which were not included in that RFI response.
As the company is looking at the projects in the RFI or other projects, is it examining where those facilities might be located in the state of Colorado?
Yes, that will be part of our considerations.
Is it also analyzing if those projects are located in environmental justice communities?
I would say yes, potentially.
Are you comparing the locations of those information to the CDPHE EnviroScreen environmental justice mapping tool?
I guess I'm not familiar with the EnviroScreen mapping tool. Perhaps you can just clarify what that is.
It's one resource the state of Colorado has to show where environmental justice communities are located. So has the company been using that tool to compare where the potential projects are?
I mean, environmental justice, Ms. Kutzer, is a really important topic for the company and something that we value highly. As far as I know, it's not a requirement for recovered methane projects under the recovered methane protocols to be located in such areas, but it's definitely a very important factor that we would consider.
Would the company commit to performing a full analysis to ensure that any proposed recovered methane projects do not have deleterious air quality or water quality impacts on the communities that host them?
I feel like that's more of a policy question that would be, better suited to be directed at witness Eiley.
No further questions. Thank you.
Thanks, Ms. Kutzer. Let me see. I think you were the last one there for cross, since you see a wave. So up to Commission Council.
I don't have any questions for this witness. Thank you.
Thank you. Commissioner Plant.
Thank you, Commissioner Gilman. I just had one clarifying question. Hi, Mr. Weinberg. In your discussion that you were just having, there was one thing I just didn't quite understand, and I was wondering if you could clarify it for me. You were asked about the bundled versus the unbundled purchases of gas, and you indicated that the company, when purchasing unbundled, would be actually purchasing the environmental attributes as opposed to the gas. My understanding was that the company was going to be getting recovered methane and injecting it into the system. What would be the purpose of getting the environmental attributes without the gas, and how would that be used by the company?
Yeah, Commissioner Plant, it's a great question, and it's something that we've definitely internally had discussions about. Our understanding of the recovered methane rules, so that regulation 22, is that recovered methane is eligible to be recovered methane credits are eligible for use within the Clean Heat Plan as long as we can establish that those recovered methane credits, that there is a displacement of fossil gas from the LDC system with this renewable source of natural gas. And if a developer, for instance, I'll just give you an example. If a developer wants to use the renewable natural gas or recovered methane for transportation fuel, for instance, but they can evidence that prior to doing that, they were relying on natural gas, fossil natural gas, or geological natural gas from an LDC, then we could still establish that there is a displacement of that geological natural gas from the LDC, even if the end use is not thermal. And so as long as that requirement is met, our understanding is that the recovered methane credit would still be eligible for use within the Clean Heat Plan.
So that even if it were used for transport, which isn't covered under this statute?
Our understanding is that as long as the developer or the end user of that recovered methane can show with evidence that they were previously relying on geological natural gas from our company or another LDC, then there would still be a displacement of that need for the geological gas, even though the end use is as a transportation fuel.
Okay, and so by purchasing those environmental attributes, you'd be able to basically claim the credit of the reduction that's created through the transportation use of the methane. And you're saying that that's a component of the AQCC methane protocol that you were following?
Yes, it's a specific clause within the recovered methane rule or regulation 22 that the department developed. And I would just add that, you know, whatever situation we're in with an unbundled recovered methane credit, we would always make sure to confirm with the department that that unbundled recovered methane credit complies with regulation 22.
I understand. Thank you for the clarification. I had no further questions. Thanks.
Thank you, Commissioner.
Thanks, Commissioner Plant. Okay, I just have a few for you. And I think this has been gone over, but as we looked at the attachment, the number is blanking on me, the responses to your RFI. It looked like many of the terms, especially for like the larger, more reasonably sized projects, were in like the 20 plus year time frame. Is that correct?
Yes, that's correct.
So I'm trying to understand, you had indicated in your testimony that recovered methane wouldn't be procured unless it was shown to be cost effective. You talked through at some length with Ms. Kutzer. I was able to get rid of some of my questions through your conversation about how would you determine what's cost effective, how will that work? It seems to me one of the fundamental frictions though is you would be needing to commit to recovered methane over a 20 plus year time frame. At least it appears in a likely case. And, you know, we've had a lot of testimony on how electrification is still in its early stages and we are unsure of the future costs. And so I guess how could we make such a long-term cost effectiveness determination when it's just this one resource that needs to be guaranteed for such a long time?
Yeah. It's a great question, Commissioner Gilman, and I think that I would like to clarify that those proposed terms in the RFI are only indicative and proposed terms. We have not agreed to anything, and we would never agree to a contract term that would extend beyond our first clean heat plan period. So that means that, you know, we would be looking at a maximum term of maybe 4 to 5 years, definitely not a 20-year term. And so we're well aware of the fact that we have a clean heat plan that has, you know, an end to the first plan. And so we would hope to align any recovered methane purchases with the term of our first clean heat plan.
Okay, that's helpful to understand. So with Mr. Dennison yesterday, you talked a little bit about pricing for the recovered methane projects. I want to make sure I'm totally clear what we're using in the modeling. So to my understanding, the RFI was kind of too late in the process to have been used in the modeling, right?
Yes, that's
correct. Okay. So you had conversations with some project developers or operators or whomever they are about Colorado-based recovered methane projects to understand pricing from them. Is that also accurate?
Yes, so there were a handful of RNG or recovered methane projects in Colorado that we were talking to the developers and we were gathering all of this input in order to model their project according to the approved protocols. And so that's all the work that E3 helped us with prior to our filing, and that was really the basis for their recovered methane input assumptions. So you'll find if you look in their model that they'll have specific project inputs and they'll have generic or archetype inputs. And so any of the specific project values in their model are based on actual recovered methane projects that are existing and that are either interconnected or going to interconnect to one of the LDCs in the near future. And some of those projects also responded to the RFI but the RFI also includes projects that we have not modeled yet.
Okay, okay. So the modeling is some subset of real projects that kind of responded to your communications with them to understand the pricing. I think during your conversation with Mr. Jennison too, you had said that getting the pricing information was successful, but procurement discussions were not successful. In other words, they were not willing or able to sell you the gas or talk further about selling you the gas. I understand some of those conversations might be confidential or whatnot, but I'm trying to figure out what to glean from that. You know, how reliable is the pricing if these aren't for sale projects?
Yeah, I think it's a really good question, Commissioner Gilman, and I would say that what we've learned from our conversations with these developers and what I've outlined in my original direct testimony is that a lot of these developers, they have an option. Either they can sell their RNG into the low carbon fuel standard market in California through the book and claim system and, you know, value stack different credits on top of each other, or they can sell their RNG as recovered methane to public service or another LDC and receive the value for the gas and the recovered methane credits. And what they indicated to us is that the value of the recovered methane credit really needs to be competitive with the alternative for them, which is the low carbon fuel standard credit plus the RFS's renewable identification number or RIN credit value. And so that's what I was referring to with kind of those conversations not being successful. It's that they indicated to us that, you know, they're expecting a significant or they're expecting to have a price that's on par with their alternative price that they could receive in the low carbon fuel standard market.
Okay, so understanding that the pricing that's in the model, I suspect you know what it is because you provided it to them. That was from these folks, although the folks are not willing to talk procurement with you, is the pricing that's in the model competitive with that cost of being competitive with the low carbon fuel standard and RIM?
Yeah, I would say for the specific projects, the prices that we have and that E3 used for their modeling, those were the indicative prices that were mentioned by the developers.
And that is the competitive price that they see. What about for the generics? Did you price the generics to also be competitive with, you know, essentially these out-of-state competitive factors?
I believe that the prices are largely the same for the generic and the specific project. So we have different prices depending on the resource type. So manure versus landfill versus wastewater. The difference is the emission reduction potential. So for some project types, you know, we're talking to a landfill, and it's what we realized is that for this landfill, there wasn't a lot of emission reduction potential, and so the abatement cost for this specific landfill project is very high. But then we also modeled, or E3 modeled, a generic version of that using the same price assumption per MMBTU, but assuming that we would find a better landfill, better in terms of, you know, the emission reduction potential. So then you'll see that the generic or archetype landfill project has a different abatement cost assumption.
Okay. And then, as I understand it, the company didn't include any sort of interconnection. I don't know if that's the right term to use here. Interconnection in terms of making the linkage between your LDC system or transmission system, wherever we can get to your system, and the project, right? That's
yes.
Just looking at the commodity price, right?
Absolutely. And just to clarify, so when we talk about with developers about procuring their fuel, that conversation is really separate from their interconnection in terms of, you know, we have an interconnection team that talks to the developer about interconnection and all of the associated costs for connecting their project to our system and injecting that fuel into our system at the right quality standard. Those costs are generally borne by the developer. And so when we talk about off-taking the RNG commodity and the environmental attributes, what we assume is that the developer will have baked in those costs in their price to make sure that, for them, it makes economic sense to sell the fuel and the attributes at that price level to us.
Okay. I mean, it seems to me like I feel like I'm hearing the commodity price is somewhat set by these outside markets, right? That set it as, well, I could just sell it into the low carbon fuel standard for X price. And interconnection could vary pretty widely, it sounds like, depending how good of access or geographically where they're located. So it seems to me like they're going to get it one way or another, right? Like it's either baked into the commodity price or it's some additional cost, but it seems to me it would live above and beyond the market price they know they can get for low carbon fuel standard, right?
I don't know if I understand your question. I'm sorry.
No, I'm just trying to understand if you're paying for the interconnection cost one way or another. If you call it a capital cost, or if it's somehow, if you have a really hard to interconnect expensive project, reasons to me it would get baked into that commodity cost.
Yeah, Commissioner Gilman, I would say that for the developer, it has to make economic sense. Ultimately, they have to make a return on their investment. And so they would need to sell their commodity and their environmental attributes at a price level that compensates for their investment, including the interconnection and injection costs. And so that's the assumption that we have. But whether the developer can make that return, I think that's up to the developer to determine, and it depends on how expensive the interconnection is. It depends on how expensive their equipment costs are. And in some cases, we've talked to developers who have come to the conclusion that their projects, wouldn't be feasible at the current levels of incentives and commodity pricing that we would be able to offer, or that they could even get in the LCFS market. And so, that's definitely a question for the developers, that they need to feel confident that they can make that return. And that's why I think you'll see that developers are really eager to have 20-year offtake agreements, because that gives them certainty. And that means that they know that they can earn back their investment over time. So that's why multi-year agreements are often preferred by the developers.
Okay. But when you have like these commodity price discussions with the developers, it doesn't sound like you get from them or understand from them exactly the degree to which interconnection costs are baked in and the scale of that.
Yeah, we wouldn't really have a breakdown of all of their costs and, understand exactly what component of the price is earning back their interconnection costs piece. But we would be talking mainly about just the overall price level. What can we pay for the commodity, which is usually very straightforward. It's just the market price of the commodity. And then the trickier part is, what would we be able to pay for the environmental attributes? And that really depends on our end, on, what's the emission reduction potential? What's the abatement cost? Is it really below a threshold where we can really confidently say this is economically, competitive? And on the other end, the developer needs to determine, at that price level, can I earn back my investment? And is it competitive with other markets, including the LCFS market? So that's all part of the kind of the commercial process that we would need to go through with each project.
Okay. And regarding the bundled versus unbundled questions, Ms. Kutzer was asking, is it fair to assume that what's modeled in the model is bundled? Just assuming, kind of the simplest take on this.
Yes. So as far as I know, what E3 has assumed in the model is all bundled purchases, including the commodity, including the environmental attributes.
Okay. Just two more questions. Regarding the coal bed methane project, I was just wondering, I read about a DOE grant that was awarded to the project. Was wondering if you had any additional information about who the recipient of that was, I don't know if the level of the award is public, but kind of what's the status on that? So any information you have on that DOE grant would be helpful.
Absolutely, Commissioner Gilman. Let me just apologize. I'm going to read from an email from the tribe. So the tribe mentioned they applied for and received a grant in the amount of $2.5 million through Senators Hickenlooper and Bennett. The grant, and that's actually a grant that's administered through the DOE's National Energy Technology Lab, or NETL. And it's a $2.5 million grant. It requires 100% match. So the tribe is required to match that $2.5 million amount. The grant was awarded to ACA Energy, and ACA Energy is a wholly owned subsidiary of the tribe. And so, does that help?
Yeah, I was just any context would be helpful. I had no idea like how big of a grant, who's are you all the recipients or not? So I thought that would be helpful. And it's my assumption that grant helps buy down the cost that then public service would be paying as part of the project.
Absolutely. I think that grant was really needed in order to make the project happen, including all of the pilot wells that they've already drilled and all of the kind of pre-project feasibility costs that the tribe has already incurred. And my understanding is that since we filed our plan in August of last year, the tribe has drilled several pilot wells, and they've confirmed that their horizontal drilling technology is indeed working. And so that's a really great milestone that they have reached. And so they are able to extract the coal bed methane from the wells that they've drilled. And so that's something that they've already confirmed. And so at this point in time, we still don't know exactly how much methane is in the coal seams. But when I talked to the tribe last week, they mentioned that, you know, they're still on track, or they still think our assumptions are in the ballpark, where we were assuming around 57,000 metric tons of carbon dioxide equivalent emission reductions per year from the project, around 130,000 MMBTUs of gas injected per year. So we're still saying that those assumptions are still in the ballpark, we think. And they hope to get the project up and running within the next 4 months or so later this year.
Okay. And your role there is procurement of the gas, or do you have some other technical partnership role?
No, we would love to procure the gas, including its environmental attributes. And again, that emission reduction, those credits. And we really hope that we can get the existing protocol for those emission reduction credits adopted by the department as a recovered methane protocol, which is, you know, what would need to happen in order for this project to be eligible, or those credits to be eligible as recovered methane credits.
Okay. And with regard to the project, is there any verification available, or does the company have information on the amount of methane annually that is seeping out of the ground in this area?
Yeah, so that's what the 57,000 metric tons of carbon dioxide equivalent per year is based on. So those are carbon dioxide equivalents, and I'm guessing it's using a maybe like 25x factor. So that would give you kind of a rough idea of how much methane is leaking that we would be capturing.
Yep. I wasn't quite sure if those would be equal, given, you know, if it's seeping now and then we, you know, pardon the lack of technical analysis here, but poke a big straw in it and start sucking it out. You know, those seem to be different rates, to me, maybe objectively. Yeah. So I wasn't sure, you know, how big is the seeping problem right now versus what we will be manually mechanically pulling. I wasn't sure how equivalent those are.
I can clarify a little bit of that. So the existing methodology only allows emission reductions to be claimed for the methane that you can evidence would otherwise have just naturally vented into the atmosphere. So what the tribe has done and what the tribe is doing right now is collecting data on how much methane is currently naturally venting through those seams. And based on that evidence, like that's what the tribe can eventually claim as the emission reduction. So it's not allowed, according to the methodology, to start like extracting more methane and then claiming those as emission reductions than otherwise would have vented naturally to the atmosphere. So that 57,000 metric tons, that is kind of a ballpark figure of what we believe the tribe would be able to evidence as what otherwise would have naturally leaked into the atmosphere without the project.
Thank you. You got to my exact question. I'm trying to figure out if we're speeding it up by sucking it out.
No, that's
Okay.
a really crucial question because that comes to the additionality piece. You know, that wouldn't be considered additional because those emission reductions wouldn't be additional to what would have happened otherwise in the absence of the project. So it's kind of a baked-in requirement of the protocol.
Okay, appreciate it. Those are my only questions. So Mr. Eisenberg, back to you on redirect. Thank you, Mr. Weinberg.
Thank you, Commissioner Gilman.
Yeah, thank you, Commissioner Gilman. Good afternoon, Mr. Weinberg.
Good afternoon.
I just want to start with one question. You were talking with Councilor Kosa and then the commissioners about this somewhat esoteric area of potential unbundled credits under Regulation 22.
Yes, that's correct.
And could you just confirm the company would only make those purchases if they're allowed by CDPHE and the AQCC, is that right?
Absolutely. Any recovered methane purchases, whether it's bundled or unbundled, we would only proceed with those if those purchases would be eligible under those department rules.
And that particular area of the protocols does not allow double counting in the sense that like the company could purchase the credit and also this transportation customer could also take credit. Is that correct?
Yes, and it's definitely something that we would want to confirm with the department is exactly what credits could the seller claim without there being an issue or conflict with the recovered methane rules. And we know that there are different credits in the market. There's LCFS credits, there's RINs, there's recovered methane credits, and we would definitely want to ensure that whatever purchase we make, that there is no double counting and that the seller cannot sell other types of credits for the same amount of recovered methane that would be considered double counting with recovered methane credits.
Earlier this afternoon, you had a conversation with counsel for COSA regarding essentially the topic of looking at potential purchases of recovered methane, comparing them to what's cost effective compared to other resources in the supply stack, and then actually executing a contract. Do you recall that?
Yes, I do.
And so we don't need to pull it up, but recalling back the RFI results, the company would do diligence to actually confirm the emissions protocol credits they would get before making any purchase.
Absolutely. And, you know, I think I touched on that in my rebuttal as well. Like we have a process that we need to follow for any of these projects if we wanted to proceed with procurement, and that includes due diligence. It includes calculating the abatement costs using one of the approved protocols. So absolutely.
And council also asked you some questions about the process for making those purchases. Could you just describe if the company has done that due diligence and determined to go ahead with a purchase, what would the effect of having to come back to the commission to go through a multi-month approval process due to the company's competitiveness in that marketplace to make that purchase?
Yeah, I think it's a great question. And our concern is, and we've seen this already with some projects, is if we don't respond quickly enough these developers are going to lock in their recovered methane sales to California, to the LCFS market. That's the main market that we're competing with. And if we want to be competitive with the LCFS market and really grow a Colorado recovered methane market, we'll have to be able to act quickly, but also, of course, being very careful with our calculations and making sure that all the calculations are correct, but at the same time going through a multi-month process to then get approval or get some kind of sign-off before we could proceed with the purchase. The concern we have is that those projects would have already locked in their sales to the LCFS market, and that would just make it even more difficult for us to procure that recovered methane.
All right, taking a step back to yesterday, do you recall a discussion with counsel for trial staff regarding public service allegedly trying to compete in the offset market?
Yes, I remember that.
Mr. Weinberg, is the company planning to develop any of its own offset projects as part of the RCNG program?
No, it's not.
Now, it is possible, as staff counsel suggested, that a customer could go out on their own and purchase some offsets to try to offset the emissions from their own personal natural gas usage.
Absolutely.
And I just found a few websites on Google this morning, onetribe.com, 44moles.com, terrapass.com. Would you agree that there are any number of places where some type of offset is being sold to the public?
Yes, absolutely true.
And none of these third-party carbon offset sellers is under PUC jurisdiction. Is that correct?
Yes, that's correct.
So a customer going to one of these third-party sellers would not necessarily know whether the offset they're purchasing is based on a project in Colorado?
No, that's not necessarily.
And nor would the customer know whether the offset they're purchasing meets any particular quality standards?
No, I don't think that's necessarily
and
the case.
Continuing on the topic of offset quality standards, do you recall a conversation you had with counsel for the city of Boulder about some accounting concerns regarding Vera offset protocols in South America?
Yes, I remember.
And the company's not planning to use any of Vera's offset protocols for verifying offsets from, say, the Amazon rainforest or anywhere else in South America?
No, as we've mentioned in rebuttal, like any of those projects for use in the RCNG program would need to be located in Colorado.
Do you also recall a conversation with counsel for Boulder regarding DTE's version of the RCNG product?
Yes.
And counsel showed you an interim order in which the Michigan Public Service Commission asked DTE to change the name of that program. Do you recall that line of questions?
I remember that question.
Could we pull hearing exhibit 130 from the company's box, please? Mr. Weinberg, do you recognize this document as the final order in the docket for that DTE program?
Yes, I do.
If we could go to page 5, please. And is the end result of that docket that the Michigan Public Service Commission approved DTE's application?
Yes, it is.
And if you're aware, do you know if the Michigan PSC has ever canceled the program or ordered it to be modified?
No, they have not, to the best of my knowledge.
Chair, I'd move to take administrative notice of hearing exhibit 130, which is an additional, it's the final order in the docket for the order that we took administrative notice of yesterday.
Any objections? All right, so admitted.
All right, switching topics. Do you recall a conversation with counsel for the Conservation Coalition? Actually, I think we've covered that. I'll skip that question. Do you recall a conversation with counsel for the Conservation Coalition? Yeah, I think Chair Gilman already covered that issue for us as well. Apologize. All right, do you recall a conversation, I believe it was also with Council for the Conservation Coalition, about whether certain markets were, in their words, nascent?
Yes, I do.
And with that conversation in mind, could you just compare the the market for RNG and the market for Colorado clean heat approved recovered methane?
Yeah, I think it's a really good clarification question. So thank you for that. Just wanted to clarify that, the RNG market nationwide is definitely a mature market, and as I mentioned in my testimony, there's more than 600 million gallons per year nationwide of RNG that's being produced. Most of that is going into the California low carbon fuel standard market. So that's a very much an established market. The RNG market itself is not nascent. What is nascent is the Colorado recovered methane market, and that's really the market that we want to grow, and we want to make sure that there are more projects in Colorado that are able to sell their gas and attributes in Colorado instead of exporting it to California. And I think that's a distinction that's important to make. So RNG market itself is not a nascent market. The recovered methane market is.
And one way to grow that market in terms of increasing the availability of projects offering into the Colorado RM market and to improve the pricing in that market would be the company's proposed spending in this clean heat plan. Is that fair to say?
Absolutely. That's exactly how we want to support and help grow this nascent recovered methane market in Colorado.
All right. Thank you very much for your time, Mr. Weinberg. Madam Chair, if no further questions, I will note we may need just a few minutes, maybe 5 minutes, to get the next witness set up.
Okay, if it's gonna take you a few minutes, maybe we'll just take a brief break now. I was gonna have to break up the next question anyway, so you guys are a few minutes away. Why don't we take a 10-minute break, come back at 2:46 with Mr. Jensen, if that works. Mr. Weinberg, you may be excused. Thank you for your testimony. Appreciate it.
Thank you, Madam Chair. Thank you, Commissioners.
All right, let's be back at 2:46 with Mr. Jensen, please.
Thank you, Chair.
Do you want to check that our court reporter is back?
Ready?
Excellent. And just to check, do you all have any plans to change out this afternoon, or are you with us till the end?
Bring me until the end.
Okay, I just want to make sure if there was another break I needed to account for, make it happen. But all right, excellent. Well, thank you. Mr. Jensen, good afternoon.
Good afternoon.
Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
And are you alone right now as you testify?
I am.
Is anyone communicating with you in any way?
No.
If that changes during your testimony, can you please stop and let me know?
Yes.
Thank you, sir. Go ahead, Mr. Roselli.
Thank you, Chair Gilman. And good afternoon, Mr. Jensen.
Good afternoon.
Could you please start by stating and spelling your full name for the record?
Michael Jensen, Michael, Jensen, Jensen.
Thank you. And by whom are you employed and what is your job?
Xcel Energy Service Company. I am the Director of Clean Fuels Project Management Office.
And you filed direct testimony in this case?
Yes.
And for the record, I would note that was hearing exhibit 108 and attachments. Does that sound right to you?
Yes.
And you filed rebuttal testimony as well?
Yes.
And that was hearing exhibit 122 and attachments. Does that sound right?
Yes, it does.
Okay, and those have been admitted into our record. Do you have any corrections to either of your testimonies here before we get started?
I do not.
Okay, with that, Mr. Jensen is available for cross-examination.
Thank you, Mr. Roselli. Okay, first up we have City of Boulder for 45 minutes. Ms. Fanging.
Good morning, good afternoon, Mr. Jensen. My name is Veronique Van Giem, and I'll be asking you some questions on behalf of the City of Boulder. We're going to be focusing on your rebuttal testimony generally today.
Okay.
And actually, we'll talk a little bit about your direct testimony first. So, in your direct testimony, you reference a variety of legal authorities to support your position that the state and federal government emphasize using hydrogen as a potential tool in achieving emissions reductions, correct?
Correct.
Okay, I'd like to walk through some of those. When we talk about the Clean Heat Statute, which is CRS 43.2108, would you agree that hydrogen blending and delivery to end-use customers were not explicitly referenced in that statute?
I can't answer that. We could pull up the statute, but I'm not that familiar to say what it included to that end.
Okay, so in your testimony, you list the Clean Heat Statute as supporting the policy stance that that the state and federal government are prioritizing hydrogen as prioritizing hydrogen. And so you don't know whether or not the initiatives the company is putting forward with regard to that policy is actually listed in the statute?
Could we pull up my testimony to verify which part you're referring to?
Sure. Can we pull up hearing exhibit 122, page 6, starting at line 6? So that's the last bullet point.
That bullet point on line 18?
Yes.
That's Bill 1281.
And then if you go down to line 21.
Okay.
So we are just wondering if there is any reference to in the clean heat statute that you reference in line 22 here to hydrogen blending and delivery to end use customers. Does a clean heat statute reference that explicitly?
You know, I'm to interpose a limited objection. I want to be clear, he's not providing a legal opinion. To the extent the witness can answer as a non-lawyer, I'm fine with that.
I think that's clear. Thank you, Mr. Roselli.
In my testimony there in lines 21 through 23, I'm calling out that the clean heat statute calls out green hydrogen as a defined clean heat resource.
Mm-hmm. Yes. So you would agree that it does not explicitly reference hydrogen blending or delivery to end use customers then?
I'm not sure with all of the wording of the statute. I know that it references green hydrogen as a defined clean heat resource.
Right. Okay. Would you agree that there are no provisions in the statute that require Public Utilities Commission to develop rules to allow for delivery of hydrogen blended with natural gas to end use customers?
You know, I'm going to have to re-raise the objection because now it sounds like we are asking for a legal conclusion about what the statute does or doesn't require the commission to do as a legal matter.
I'm just rebutting his statement that we are just using this line of questioning to rebut his statement that all of these listed legal authorities support the company's program in the way that it's exploring hydrogen as a clean heat resource.
Can you re-ask your question? Sorry.
Re-ask it?
Yeah, just so I can have it fresh.
Would you agree that there are no provisions in the statute that require the PUC to develop rules to allow for the delivery of hydrogen blended with natural gas to its end use customers?
I think with the caveat that you're not asking him for a legal opinion if he's aware of reference in the statute to that.
Right.
I'd expect he might be able to answer the question.
Absolutely.
As I understand your question, I'm not aware or familiar enough with the statute to answer that.
Okay. So another legal resource that or legal authority you referenced to support the policy initiatives of the company are the new source performance standards for reconstructed fossil fuel fired power plants. And so these standards only reference the use of blended hydrogen in the context of electric generation, correct?
I believe that's correct, yes.
They do not reference providing blended hydrogen delivery to end use customers. Is that right?
Not that I'm aware of.
Okay. Let's go to Colorado House Bill 23-1281. So this bill concerns measures to advance the production and use of clean hydrogen. This bill also does not reference blended hydrogen delivered to end use customers. Would you agree with that? For the use in gas combustion appliances specifically.
Again, I can't comment to the exact wording of the entire standard.
Okay. Would you agree that the bill specifically defines clean hydrogen as hydrogen that is derived from a clean energy resource that uses water as a source of hydrogen?
Could we pull that up and see that language, please?
I actually do not have the bill in front of me, but subject to check.
Well,
will you repeat the question, please?
I'm going to make another objection with due respect. It's awfully difficult to ask the witness to confirm language that's not even put in front of him.
Yeah, that's fair. We'll move on. So, would you agree that in your rebuttal testimony, you state that safety is a core value of the company?
I believe I have that in my rebuttal, yes.
And you go on to provide that the company's expertise in safe handling and operation of natural gas systems will readily apply to natural gas blended with hydrogen, correct?
Could we pull that testimony up as well, please?
Sure. Here in Exhibit 122, page 17, line 4.
And then will you tell me that question?
Restate the question. Yep.
Yeah, thank you.
So you provide that the company's expertise in safe handling and operation of natural gas systems will readily apply to natural gas blended with hydrogen.
Your question didn't state it word for word, but that's generally what the statement reads as.
Okay. And you agree that hydrogen is a smaller molecule than methane?
That's correct.
Would you agree that hydrogen embrittlement is generally defined as mechanical damage caused by hydrogen penetrating into a material and reacting with that material?
I generally would agree with that. I'm not a material science, so I can't tell you the exact definition.
Okay. And steel and aluminum alloy are among the materials most susceptible to hydrogen embrittlement, correct?
I can't agree or disagree with that.
So steel and aluminum alloy are materials that are susceptible to hydrogen embrittlement, correct?
Perhaps under certain conditions.
Okay. A customer could be served by a polyethylene pipeline to the gas meter, but then have steel gas lines on their side of the meter. Is that correct?
That's an infrastructure question that would be better served for Mr. Ray Gardner.
Okay. Thank you. Are you familiar with how the company inspects the mechanical properties of its pipelines?
No, I am not. That's again a question for Mr. Ray Gardner.
Okay. I will reserve these for him. Okay, so let's switch topics. In your rebuttal testimony, you describe a project done in the United Kingdom by High Deploy, correct?
That's correct.
And this project ran from 2019 to 2022.
I believe it is ongoing.
So can we bring up page 18? It's still hearing exhibit 122, which you had up. Apologies. Page 18, line 9. Where you describe that phase 2 of the study ran from, well, 2021 to 2022 here.
Can you repeat then the question? I apologize. I see
Yeah,
the
we wanted to know whether you knew if the project ran from 2019 to 2022.
So in the reference that we're showing on line item or in line 11, the phase 2 of their program ran from August 21st to June 22nd. I believe the first phase was started in 2019, though I don't remember the exact dates.
Okay. And hydrogen embrittlement is a process that can occur over an extended period of time. Is that right?
Perhaps I'm not a materials expert.
And an issue that does not show up in the first 3 years of a study like this could still occur at year 5, for example, correct?
I do not know.
Would you agree that the risks posed by blended hydrogen may have an impact on insurance premiums and appliance warranties?
I'm not familiar with insurance policies and appliance warranties to answer that.
Okay, that's all my questions.
Thank you.
Thanks, Ms. Van Diem. Let's see who's up next here. Conservation Coalition for 20 minutes. Mr. Jennison.
Good afternoon, Mr. Jensen. My name is Jim Dennison, and I'll be asking you some questions on behalf of the Conservation Coalition. So I want to start by just making sure that I understand the company's latest hydrogen proposal correctly, because I know there's been some discussion on that. So I'm just going to walk through it one step at a time, and you can tell me if I have it right, okay?
Okay.
So the company's not proposing to move forward with a residential hydrogen blending demonstration project until the proposed 2026 check-in, correct?
I believe that's correct, and I think Mr. Eiley laid that out.
Okay, and if it would help to reference, I know you discussed it, Mr. Eiley discussed it a bit, but I think I have some questions that are appropriately directed to you, and if we need to pull up your testimony, that's fine. But so as far as you know, we're together so far?
Yes.
Okay. And you're not proposing to cancel that residential demonstration project, just extend its timeline, correct?
Correct. That's how I described it in my rebuttal testimony.
Okay. And you continue to believe that the demonstration project is a foundational step toward potential hydrogen blending at scale. Is that right?
I want to just ask for a clarification. You said the demonstration project, so I don't know if you're talking about the project that was as originally proposed, or if you've pivoted to generically hydrogen demonstration project. So if you could clarify the question.
Sure. I'm asking about this this residential demonstration pilot that we've been talking about as modified and extended in the rebuttal proposal.
So we believe that the hydrogen demonstration project is an important step.
Okay. So the company isn't proposing to pursue hydrogen blending through the main clean heat compliance portfolio until after it completes the residential demonstration project, right?
We haven't proposed any hydrogen blending, as I understand it, in the clean heat process.
Well, so okay, I just want to make sure we're still together here. I think we talked about your continued interest in the blending demonstration project, and I think you said that it's important to continue with that before pursuing broader scale demonstration. So I'm just asking, the company doesn't intend to pursue broader blending as part of the main compliance portfolio until after completing that demonstration project. Is that right?
I don't believe we've stated it in that exact way. We've talked about the importance of doing the blending demonstration project to learn and get better understanding with blending.
All right, I understand a significant driver in this proposal to push the timeline back and do some of these other smaller scale or limited demonstration projects before pursuing the residential pilot was to alleviate some of the concerns that had been expressed by parties to this proceeding about that project, that residential project itself. Is that right?
Hearing the feedback that we got from various stakeholders was an important input into our process.
Okay, and so I guess what I'm trying to understand is if you continue to believe this demonstration project is important and you seem to have registered the concerns about that project, it seems to me that it would make sense to do that project before proceeding to broader scale blending on the company's system. And I just want to understand if that's the company's proposal.
We haven't proposed a specific step-by-step or set decision point as to when we go from one step to another.
So you can't commit to completing the residential demonstration project before pursuing broader scale blending on the system. Is that your testimony?
I don't think that I'm in a position to commit to any company plans.
Mr. Jensen, I was trying to interpose an objection, but we'll move ahead. That's fine.
Okay. And I guess I'm not necessarily seeking a commitment from you, Mr. Jensen. I'm sorry if it came out that way. I just, again, trying to understand the company's proposal as it is on the table now. And I guess I'm not hearing a commitment or a proposal to complete that residential demonstration pilot before pursuing broader scale blending. Is that right?
I don't believe we have articulated that specific series of steps as you described it.
Okay. Well, maybe just to wrap up my clarifying my understanding here, and then we'll move on to another topic. The residential demonstration project would be a 2-year project. Is that right?
Yes, that's correct.
Okay. So just working through the timeline here, if the company were to complete the residential demonstration project before pursuing system-wide blending, and that project isn't going to be starting until after the 2026 check-in, then the company wouldn't be in a position to pursue hydrogen blending as part of the main clean heat compliance portfolio in this 2024 to 2028 clean heat plan. Is that right?
I'm going to object because it misstates the testimony, because I don't believe there's any testimony about introducing system-wide blending.
If I could respond.
Yeah, Mr. Johnson.
I would say the question is framing up a hypothetical, as I understand the timeline would work. And the company's rebuttal does include budget for hydrogen blending in the 2027 and 2028 program years.
If I could respond further, Chair Gilman, I would certainly acknowledge that's true. However, the supplemental direct testimony filed by Mr. Ray Gardner makes clear that the company's not talking about what's been, I think, mischaracterized as system-wide deployment. Rather, it speaks to a very focused and targeted initial deployment of hydrogen. So I'm reacting to the mischaracterization of the testimony as system-wide deployment. That's my objection.
Mr. From what I understood in your question, you were asking the witness if it was correct. I'm generally okay with a question like that. I feel like if you mischaracterize the company's position or his testimony, he'll correct you, since you're asking him if it's correct. So I would overrule it. Thank you.
Okay. And if I might clarify, however the company chooses to describe blending that would happen through the main clean heat compliance portfolio, whether that's targeted to certain parts of its system, that's fine. I'm just asking, in this sequence in which the residential project would conclude before whatever that broader blending, however focused it may be, would occur. I just want to understand the implications of that timeline.
So I believe as you described this, as you described a hypothetical starting, if the hydrogen blending demonstration started in 2026 and lasted for 2 years, that would have it completed in 2028. So I believe your math is correct.
So in that situation, the company would not be in a position to be using budget allocated for hydrogen blending as part of the main compliance portfolio before 2028, correct?
Could you say that one more time, please?
Yeah, just clarifying that in this situation we've been discussing, where the demonstration project runs through 2028, and if the company doesn't pursue blending through the main compliance portfolio, then the company wouldn't be in a position to be spending budget from the main compliance portfolio on hydrogen blending before 2028.
If the hydrogen blending demonstration project didn't start until 2026 and lasted for 2 years, and if the company made a decision to not do any type of blending prior to that completing, then that would have to happen outside of this current clean heat portfolio. I believe that's what you've described.
Okay, thank you. We can move on now to some questions about the availability of green hydrogen. So you say in your rebuttal testimony that there are few sources of green hydrogen available today, correct?
Could you bring that up, please?
Sure. It's exhibit 122 at page 20, line 4.
Okay.
All right. And you've stated in a discovery response that you're not aware of any existing sources of green hydrogen in Colorado, correct?
I believe that was in a discovery response. I think that was correct. I don't know. I don't recall which one you're referring to, though.
Sure, I'd be happy to pull it up. If we could go into our box, the document marked hearing exhibit 604.
Sorry, you said 604, right?
Yes. All right, do you see that, Mr. Jensen? And
Yes, I
if
do.
we
Thank
could
you.
scroll down. Do you recognize this as a discovery response and see you listed there as the sponsor?
Yes, thank you.
All right, I would move the admission of exhibit 604.
No objections from the company.
Thanks, Ms. Priscelli. So admitted.
Okay, so we'll finish talking through this for one moment and then we can pull it down. So that first question, you said that you're not aware of any existing sources of green hydrogen in Colorado. Is that right?
Oh, that are available today. That's what my testimony said, yes.
Okay. And you aren't aware of any green hydrogen projects that are under development in Colorado either, right?
That's correct.
And you were not able to identify any sources of green hydrogen that the company expects to become available to it from 2024 to 2028, were you?
No.
All right, I think we're done with that exhibit for now. Thank you. So the company is asking the commission to approve the use of hydrogen and its clean heat portfolio based solely on the company's belief that green hydrogen sources will materialize in the future, correct?
I don't believe it's solely on the company's belief, no.
Well, we just talked about the lack of existing sources. So if other sources don't materialize, on what basis would the company be asking the commission to approve green hydrogen use? I guess that's my question.
I believe in my rebuttal testimony, I referenced the production capacity of electrolyzers for green hydrogen projects that were increasing. And so it's not a sole company belief. It's based on information that we have throughout the industry.
Okay, that's fine. I think we've confirmed those don't exist in Colorado, and so they would need to come to exist in Colorado in order for the company to use them. Is that fair?
If the company wanted to use a project in Colorado, it would need to be in Colorado. I agree.
Okay. And without knowing whether or what sources of green hydrogen will be available to the company, you can't know what quantities of green hydrogen will be available in 2020 in Colorado from 2024 to 2028, can you?
I think that's correct.
You also can't know the specific cost at which the company could procure green hydrogen during those years, can you?
No.
All right. We'll switch to another topic now. You note in your rebuttal that green hydrogen is a listed clean heat resource, correct?
That's correct.
But the clean heat statute only identifies green hydrogen as a clean heat resource, right?
I don't believe that's correct.
Okay, we can pull up the language if it would be helpful to look at that. Would it be helpful, Mr. Jensen?
Yes, thank you.
Okay, so it's reproduced in hearing exhibit 1400 at page 98. And I'm looking at line 20 there. So you recognize this as a list of clean heat resources under the clean heat statute?
Yes.
And you see green hydrogen listed there, right?
I see green hydrogen listed, yes.
Does the statute list any other forms of hydrogen?
I don't see that it specifically calls out any other hydrogen in this page.
So it doesn't list blue hydrogen, for example. Is that correct?
I don't see it on this page.
Fine. The method by which hydrogen is produced affects the emission reductions that can be achieved by using that hydrogen, correct?
Yeah, I believe that's correct.
Okay, and thank you. We can pull the exhibit down now. So, for example, all else being equal, a blending project that used gray hydrogen, that would produce fewer emission reductions than a blending project that used green hydrogen, correct?
What is gray hydrogen what do you mean by gray hydrogen?
I think the common definition is hydrogen produced from steam methane reformation.
Okay.
So you'd agree with that?
Say the question one more time, sorry.
All else being equal, a blending project that used gray hydrogen would produce fewer emission reductions than a blending project that used green hydrogen. Would you agree?
I would agree with that, yes.
Would the same be true for a blue hydrogen project that would produce fewer emission reductions than green hydrogen?
I think that is generally true as well, yes.
Okay. Are you aware that the commission must consider air quality, environmental, and health issues when approving a clean heat plant?
Not specifically.
Would it help to pull that language up?
Sure, thank you.
All right, that's it. Hearing exhibit 500, page 46. And it's at line 14. That's a little small, but do you see in the list of factors to consider in determining whether a clean heat plan is in the public interest, environmental health and air quality issues listed there?
I see that line 14, yes.
Okay. Is it fair to say that air quality, health, and environmental issues are among the concerns that interveners raised with the company's hydrogen blending proposals?
I believe those topics were included in some of the intervener comments.
Okay. And thanks, we can pull the exhibit down again. So specifically, one of the concerns was the potential of hydrogen blends to increase indoor and outdoor air pollution from gas combustion, right?
Was that in a specific discovery?
This is raised by interveners in their testimony, and we can pull up an example if that would help.
Yeah, sure, that would help. Thank you.
Okay. This is back at hearing exhibit 1400 at page 61. And starting at line 13, there's a discussion of nitrogen oxide emissions related to hydrogen blending. Do you see that there?
Yes, I see that. Yeah.
Okay. So would you agree that interveners had raised concerns about the potential of hydrogen blends to contribute to indoor and outdoor pollution from gas combustion?
That's what this statement looks to be implying.
And I think we're done with the exhibit now. Are these concerns we've been talking about among the concerns that you characterize in your rebuttal testimony as, quote, directly challenging a policy determination already made by the Colorado legislature?
Can we bring up my testimony for that statement, please?
Sure, it's in your rebuttal, exhibit 122, page 15, starting at line 8.
And if you don't mind, tell me your question one more time.
And the question was whether the health, environmental, and air quality concerns that we've been talking about are among the concerns that you characterize as challenging a policy determination already made by the Colorado legislature.
No, I'm not sure on how to characterize that. This statement is a broad statement to say that there was a lot of different topics brought up challenging hydrogen. And I agree with you that the health and safety were among the topics that were brought up.
Okay, so is it the company's position that the commission should not consider the health and environmental effects of hydrogen blending as part of a clean heat portfolio just because green hydrogen is listed as one of the clean heat resources that could potentially go into a portfolio?
And object that does call for a legal conclusion.
Mr. Dennison, can you rework it so you're not asking him to draw a legal conclusion?
Sure. Does the company think that it's appropriate for the commission to consider health and environmental impacts of hydrogen blending part of a clean heat portfolio?
Can you say that one more time, please?
Yeah. Is it your testimony or is it the company's position that the commission should consider the health and environmental effects of hydrogen blending as part of a clean heat portfolio?
I don't state that specific thing in my testimony, I believe, and I don't know if the company has made that recommendation.
Okay, well, I'm not asking about your written testimony. I'm just asking if you think it would be appropriate for the commission to consider those issues in making a determination about whether to include hydrogen blending in the company's portfolio.
What I think the commission should decide, is that what you're asking?
If you think it would be appropriate to consider these factors.
I think that the commission is gonna probably listen to all of the interveners and topics that come to them.
All right, that's fine. We can pull this exhibit down now. I've got just a couple follow-ups from our earlier conversation, and then we can wrap up. As we talked about earlier, you're aware that in the company's flex portfolio, the company is proposing to spend money in 2027 and 2028 on hydrogen, correct?
The flex portfolio does have dollars set aside for hydrogen in 2027 and 2028. I believe that's correct.
And do you know what exactly the company is proposing to do with the $5.7 million listed for hydrogen in 2027?
So that those dollars came out of the E3 model as to that would be the prospective cost of that volume of hydrogen.
So my question is, can you tell me what the company is proposing to do with that money?
No, I cannot.
Do you know exactly what the company is proposing to do with the $20.1 million budget for hydrogen in 2028?
Not specifically today.
All right, thank you. That's all my questions.
Thank you.
Thanks, Mr. Jennison. Next I have WRA for 30 minutes, Mr. Bursa.
All right, thank you, Chair Gilman, and good afternoon, Mr. Jensen. My name is Parks Barroso, and I will be asking you some questions today on behalf of Western Resource Advocates.
Good afternoon.
I don't believe we've had the chance to meet before. It's nice to meet you, sir.
Nice to meet you too.
And so, Mr. Jensen, I'd like to start with what I hope will just be a clarification question. And I'm looking at your rebuttal testimony, hearing exhibit 122. And here on page 10, you provide an update on the status of the hydrogen hub applications that Xcel Energy is involved with. Do you recall that?
Yes.
And down on line 19, you identified the Heartland Hub, of which Xcel is a part of that application pool, and that it was selected for an award.
Correct.
And where would that hub be located?
As of today, the identified projects that were part of the Heartland Hub application were in the states of Minnesota, South Dakota, and North Dakota.
Thank you. And so is the company proposing that any hydrogen might be transported from that hub or those projects to Colorado? Or was this reference to the hub merely provided as an example of the company's hydrogen hub efforts?
In our application, we don't propose any transportation of hydrogen from those states to Colorado.
And so that's what was proposed in your application. Is it still the case today that the company is not intending to transport hydrogen from those locations to Colorado?
So the scope of our scope of work within the Heartland Hydrogen Hub is right now subject to change based mostly on our negotiations with the Department of Energy, as well as the finalization of the 45V hydrogen production tax credit.
Okay, so I guess maybe to put it differently, Mr. Jensen, could you rule out the possibility that hydrogen would be transported from those project locations to Colorado, or is that still subject to those negotiations that you've referenced?
I can't rule out any scope changes for the Heartland Hub because of those things that I mentioned.
Okay, so it's possible that XL could seek to transport hydrogen from those locations to Colorado.
Potentially that, or perhaps even in pursue other connections with Colorado.
I'm sorry, what do you mean by other connections with Colorado?
As I state later on in my rebuttal testimony, we received positive feedback from the Department of Energy on our Colorado Hydrogen Hub application, and we're still working to identify opportunities to pursue hydrogen production in Colorado.
Okay, so that's a separate issue from this Heartland Hub specifically. Is that right?
I don't know.
Okay, we can move on. Mr. Jensen, did you happen to be observing the hearing back on Monday?
Off and on, I was watching it for some of it.
Okay, and if it's been a long hearing already, so you might have missed this, but to recap, I'll represent to you that I had a conversation with your colleague, Mr. Eiley, where we discussed infrastructure investments associated with the deployment of hydrogen.
Okay.
And would you agree with me that the deployment and use of hydrogen on the gas distribution system will require the company to make infrastructure investments?
I think that kind of question is better suited for Mr. Ray Gardner.
Well, let's turn to we're on the right hearing exhibit 122. Can we go to page 7, please? And looking here at line 3, here, Mr. Jensen, you state, quote, "The use of hydrogen will ultimately require investment in new assets and potential modifications to some existing infrastructure. Such investments takes time, capital, detailed planning, and collaboration with stakeholder groups."
I see that.
And so to restate my earlier question, based on this testimony that you've provided, would you agree that the deployment and use of hydrogen on the gas distribution system will require that the company make infrastructure investments?
As I have in right there, in that it's potential.
I'm looking for the word potential in that sentence that we just read. I see that you say the use of hydrogen will ultimately require investment
in new assets and potential modifications to some existing infrastructure.
And so those investments in new assets, is that referring to infrastructure investments, or is that some other type of investment?
That would primarily be thinking about assets in terms of the production of hydrogen.
And for the interconnection of that hydrogen to the company's system, would that require any investment into new assets or new infrastructure?
Potentially.
I guess, could you help me understand the potentially there? How would new hydrogen production be interconnected to the system without the existence of that infrastructure?
So I cannot speak in detail of that. Again, that's where you'd have to go to Mr. Ray Gardner to talk about the gas infrastructure.
Okay. And we can move on, Mr. Jensen, to another section of your rebuttal testimony on page 24. And here you're responding to claims that hydrogen is an ineffective tool for emission reductions. Do you recall this part of your testimony?
Yes.
And at line 2, you state, there are a few other options available today that can deliver the kind of emission reductions with no requirement for customer action or input.
Yep, I see that.
And just for the clarity of the record, should we take this to mean that it's your belief that one of the benefits of hydrogen as a resource is that its deployment does not require any customer action or input?
The intent of this statement is to say that it doesn't require customers to change habits or appliances.
And so regarding the word on the page here, input, is it your position that for hydrogen blending on the gas distribution system, there should be no requirements for customer input?
That's not a position that I'm taking, no.
Okay, so would you agree with me then that the commission could establish some requirements that allow for customer input prior to gas being blended in the distribution system?
I'm not totally familiar with commission processes of how they would do that.
Let me rephrase that. Do you think, Mr. Jensen, do you think it would be valuable for residential customers before hydrogen is blended onto a part of the system that serves their home? Would it be valuable for them to have the opportunity to provide input?
I think it's always important to hear from our customers.
And I appreciate that general answer, but just as a specific question regarding hydrogen blending on a section of the system that serves residential customers, do you think it'd be valuable for that particular subset of customers to have the opportunity for input?
I think it's depends on how it's happening and the customer base. Again, I think it is always important to communicate and hear from our customers.
Okay, and we can move on now to a slightly different topic. Ms. Federico, if we could please scroll up now to page 19. And I'm looking at line 17. And here, Mr. Jensen, you state that interveners, for all their collective testimony expressing concern regarding hydrogen, provide only rhetoric and no concrete evidence to suggest that the company will not be able to safely blend hydrogen. Do you remember saying that?
I'm sorry. I don't see a 17 on there.
Yeah, the screen's not matching what you're reading, Mr. Barrasso, for some reason.
Yeah, you said, what page did you say? I thought you said 19, but there's no line 17 on page 19.
I apologize. I'm looking at page 18, not 19.
There we go.
All right, Mr. Jensen, let's try that again. Starting here at line 17, do you see that phrase that I just referenced?
I see line 17.
And so is it still your testimony today that interveners have provided, quote, no concrete evidence that calls into question the safety of hydrogen blending?
I haven't made any changes to my testimony.
Okay, Ms. Federico, could we please pull up hearing exhibit 1401, attachment BC1?
I'm taking the public one unless I hear otherwise, just so you know.
Yes, please. Thank you. Mr. Jensen, this is an attachment that was provided along with WA witness Mr. Sabukol's testimony. If we could turn to page 20 of this, please. And feel free to take a moment to familiarize yourself with this if you'd like, but I'm looking at what's marked here under the header titled 4, risks of blending hydrogen greater than 5% by volume. Do you see that?
I see that. Yep, number 4.
Thank you. And Ms. Federico, if we could just scroll down a bit, I'm looking for that second paragraph in that section. And the third, yes, that's perfect. Thank you. The third sentence there reads that recent analysis by the National Regulatory Research Institute of Hydrogen Burning Appliances has found that blend percentages greater than 50%, apologies, let me restart that. Recent analysis by the National Regulatory Research Institute of Hydrogen Burning Appliances has found that blend percentages greater than 5% by volume can result in unsafe ignition conditions for home appliances, such as water heaters and stoves. Do you see that there?
I see that.
Thank you. And Ms. Federico, apologies for all the switching around, but could we now please pull up what's been pre-marked as hearing exhibit 1408 in WRA's box? And just zooming out a little bit, there we go. Mr. Jensen, this is that report that we just walked through that was prepared by the National Regulatory Research Institute and was prepared for this commission, for the Colorado Public Utilities Commission. Do you see that?
I see the document. In the document that we just looked at, it didn't reference the exact name of what it was referring to.
And if we could please scroll to page 6 of this document. And looking at the bottom here, continuing on to page 7. Mr. Jensen, do you see that this describes the summary of findings of this report?
I see the summary of findings, yeah.
Great, and just scrolling down a little bit more, please. Do you see the bullets here? Infrastructure compatibility and equipment compatibility?
Yeah.
And looking at that equipment compatibility bullet, do you see that it states that commercial and residential customer end-use equipment compatibility issues represent a significant and perhaps meaningfully limiting challenge for hydrogen blending?
I see that, yes.
Thank you. And Chair, I'd like to move for admission of this hearing exhibit 1408.
Mr. Roselli,
No objections.
so admitted.
Thank you. And so, Mr. Jensen, having walked through just this one exhibit and the previous exhibit attachment BC1, would you maintain your testimony that we discussed earlier, which is that intervener's testimony is simply rhetoric and does not provide concrete evidence?
I'm going to object. That mischaracterizes the testimony that Mr. Brasso was referencing, because if I can go back to the testimony, it expressly said that the rhetoric we're talking about in intervener testimony had produced no evidence that the company cannot safely blend hydrogen. These are generic reports and studies, like many other generic reports and studies done on hydrogen blending impacts. They do not go specifically to what Public Service Company of Colorado can or cannot do. That was the statement in the testimony.
Mr. Grosso.
If I could respond, I think it's just an important point for the record here and the quantum of evidence that the company believes is or is not needed to establish whether hydrogen can be blended safely in the gas system. And so to the extent that studies reference gas systems. Generally, I think that they're relevant to public services gas systems specifically.
You run your question by me one more time.
Sure, and my question was, Mr. Jensen, based on your review, and I understand it's been a brief review here on the stand of this report, along with other interveners' testimony that you've reviewed, is it still your testimony that interveners have provided only rhetoric and no concrete evidence to suggest that the company will not be able to safely blend hydrogen?
Thanks, fair question. Go ahead.
In the amount of what we've seen in this document that you're showing right here, I'm not seeing any evidence. It just the statement that there's perhaps limiting challenges for hydrogen blending.
And by evidence, is it your position then that interveners would have to provide documents that are specific to public services system?
My testimony was in reference to public services system.
And your testimony here now in our discussion is the same, that the only evidence that, let me rephrase that. In our discussion here, is it still your testimony that the commission should only be considering evidence that's specific to public services system?
I'm going to object to that. Again, mischaracterizes his testimony. He didn't state that the commission should only consider evidence specific to public service company. He stated that interveners had not presented any evidence specific to public service company. It's a different concept.
Okay. Mr. Jensen, do you think the commission should not consider evidence that is not specific to public services gas distribution system?
Say that one more time. So
I apologize.
Double negative. See if you can work that in a way that's a little clearer.
Do you think that the commission should consider evidence that is not specific to public services system?
I think that depends.
Okay, Mr. Jensen, I have no further questions for you. Thank you for your time.
Thanks.
Thanks, Mr. Broso. Ms. Kutzer, I have Kosa up next for 15 minutes.
Chair Gilman, Kosa's going to waive our cross of Mr. Jensen. Thank you.
Okie dokie. Let me see. Okay, commissioner questions. First, commission counsel.
No questions for this witness.
Oh, and Ms. Dundas, thank you. Commissioner Plant.
Thank you. I only have one question, just out of curiosity, as it relates to the demonstration project that the company is proposing. And as I understand it, this is going to be done in a contained environment if it gets approved as a sort of a testing environment. I think that the UK project that you talked about was done on a maybe a university campus, if I recall correctly.
It was a small sort of community. Yeah.
Yeah. But since you'll be doing it in a contained environment, I'm assuming that you'll be measuring any combustion impacts with various different appliances indoors, and determining whether or not there's any kind of adverse impact at various different blending percentages.
So those kind of details, Mr. Ray Gardner can give you much more details, but in our proposal to do hydrogen blending at a company facility, I think that kind of those types of actions would definitely be things that we wanted to do for sure.
Okay, great. And I can talk to Mr. Gardner a little bit more about it. I did bring this up with Mr. Eiley, and I was just curious, and maybe you know, or maybe maybe you don't know, but there's a project that the Colorado School of Mines and the USGS are engaged in on geologic hydrogen. I don't know if the company has been engaged in that at all, or is a partner in that project.
So I'm aware of it. We're not officially connected with them, but we are tracking that type of geologic hydrogen, also called gold hydrogen, on the rainbow of hydrogen colors.
I didn't know it had a color yet. That's good to know.
They all have a color, right? So that one is gold hydrogen, like maybe like reference to black gold type of thing. But yeah, no. So we're not connected to the School of Mines one. We are sort of tracking it, as well as starting to talk with other potential companies that are looking into it. That one is sort of a really new, exciting, growing thing right now. That like the U.S. Geologic Survey is right now working to map out where are the potential sites that geologic hydrogen could be producing.
Yeah, understand. Okay, great. Thanks. I didn't have any further questions. Chairman Gilman.
Thanks, Commissioner.
Thanks, Commissioner Plant. Good afternoon, Mr. Jensen.
Hi.
Okay, I have a few for you. I'm a little confused on the line between you and Mr. Gardner, so shoot me straight if I'm going into his area. So is it correct that part of the new demonstrations the company is proposing with regard to hydrogen are some kind of testing of typical customer gas appliances as part of the kind of facility testing, or something different?
Yeah, and I'll speak generally, and again, Mr. Gardner can talk in much more detail. But as we want to define that as using our company facilities to test out hydrogen blending with perhaps a variety of appliances.
Okay, and I think it's in Mr. Gardner's testimony, but he generally references that the company has indicated they have access to a significant volume of evaluative work that's been done on the use of blended hydrogen. Would you generally agree with that?
We are trying to gather a lot of information, and we're involved in a handful of different activities. Yeah, so and probably one of the main ones that he would refer to is the High Blend study, which is a DOE and NREL effort that's happening right now.
Okay, so as part of this kind of testing facility and appliance testing that goes into that, I'm aware that several relatively prestigious higher education facilities that have done studies similar to this, including National Renewable Energy Laboratory, several of the universities in California. So trying to understand, are you all proposing to partner with any sort of more official kind of testing or educational outfit, or is this really just something the company would be doing on their own?
I think it would be best if we partnered with other organizations for something like this. This type of work, we would benefit from that kind of thing. And we're members of the Electric Power Research Institute, and they've got a program called LCRI, Low Carbon Resource Initiative. And part of that also includes the Gas Technology Institute. And so they've got a mechanism for proposing projects similar to this. And so we've got some already avenues of potential partnerships that we could look to, I think.
Okay, but has the company had any of those discussions yet, or secured any partners for a project like this?
We haven't secured an exact plan for it. No, not yet.
Okay. Also, and I think this from Mr. Gardner's testimony, again, I apologize, but I think it's very relevant to the things that you testified to as well. He knows that where there's a significant volume of evaluative work on the use of blended hydrogen available to us, and we've done preliminary evaluative work to our system, the actual blending is important, is kind of his statement. So I was wondering if you can detail for me what the preliminary evaluative work the company has done specific to your system is to date.
I was a part of a study that we worked with an outside firm to do some high-level conceptual evaluation of the system, which we have the results and we're trying to better understand those.
Okay, and when did you all complete that work?
Let's see here. The final report from that outside firm came in, I believe it was in December. I think that was it. Yeah, the one that I'm thinking of.
So you might not be aware, but Commission Rule 4553 D2, which is part of the gas infrastructure plan rules, requires the company to include information to the extent it's known on the percent of the company's distribution system components that are known to be compatible with safely carrying different volumes of hydrogen, and to identify any areas of the system with materials that are known to be incompatible with carrying a mixture up to 20% hydrogen. Are you familiar with that requirement in our commission rules?
Only just recently have I been aware of that. I think that's part of the GIP rules, right?
Yeah.
And only recently have I seen that.
Okay. And the company didn't provide any specific technical details on the system or its compatibility with hydrogen. Is that something that's available now through the research that the company has done?
I believe that one or more of the studies that we've done came through some discovery, and so I think that is available
in this proceeding.
Yeah, I believe so.
Okay, Mr. Roselli, maybe if you can follow up for me and figure out if that's in the evidence. I'm interested.
We are happy to do that, and we can have that discussion if you'd like to see the record supplemented. I think the nature is that some documentation was provided in discovery, but it's not been made an attachment by any of the intervening parties. So it's not in the record at this point.
Okay, thank you. So I think the company generally acknowledges concerns about not knowing the source of hydrogen or its carbon intensity for at least the demonstration projects at this time. And, in rebuttal, the company kind of indicates that any demonstration project would be a relatively small amount, but would you agree it might be tough if we're looking at the odd position of potentially increasing carbon, at least in this segment, if the use of that hydrogen, even in a demonstration project, were not kind of in a way that allowed us to use lower carbon resources?
Right. Yeah. So the hydrogen blending demonstration project, as it was laid out, you're right, is very small volumes, but also if we were to use hydrogen that had a larger or had a carbon footprint, you're right, that wouldn't be helpful for overall greenhouse gas emissions kind of thing. But we haven't identified where that hydrogen would come from yet, and have been trying to identify where we could potentially get green hydrogen for that blending demonstration project.
Okay. But the company doesn't know the source of it now, and may or may not know the source of it in whatever the timeline is to propose an actual project if the company chooses to do so.
We don't know today. You're right. No.
Okay. One more question on the kind of compatibility of the system, and then I have something else. So back to the question that I think it was WRA was asking regarding your statement about for all their collective testimony expressing concern regarding hydrogen, the interveners provide only rhetoric and no concrete evidence to suggest the company would not be able to safely blend hydrogen. You recall that statement? Yeah. And I'm just trying to sort this out. I mean, is it your understanding that the burden would be on the company to prove it is safe, or on someone else to prove a negative that they know that it is not safe in particular in your system?
Well, I think it's on us to demonstrate our safety practices and procedures and how we intend to handle and operate the system with hydrogen for sure. That's part of our operations and what we do.
Okay.
Did that answer your question? I'm sorry.
Well, I think a lot of the concerns I'm hearing are less about operating practices and procedures and more about the actual materials and components and impacts on them within the system.
Sure. And I think that's it is an important part of identifying where and how much that we would blend into the system. And I think it is in Mr. Ray Gardner's testimony that whenever we started on the system beyond a demonstration project, it would be very targeted kind of locations where we would be able to understand that those compatibility issues and all of those things in a very detailed way.
Okay. Within reason, if the company started blending hydrogen at large into the system, which I think is in the model budgets for 2027 on or so, unless I'm misunderstanding, you can help me. Prior to that, you anticipate the company would have a full accounting of all of the components in the system and their compatibility?
Well, so if I can correct you in terms of that model, it has a volume of hydrogen, right? And it says this volume is would represent a blend of 1% and 4%. But that's again where Mr. Gardner's statement goes, is that we wouldn't actually say we're doing 1% across the system in that year. It's more so that volume would then be used in specific targeted locations first and foremost, because to say scale blending is I think a very large endeavor, and he could probably detail exactly all the challenges around large scale. But just sort of what you're getting to is we would need to understand all of those things.
Okay, so in reality, your proposal would be to use it in segmented geographic areas at higher concentrations than the 1%. It's mathematically equivalent to 1% across the whole thing, but actually we have higher concentrations in smaller areas.
I think so. Yeah, that's right.
Any proposal on how big or what those concentrations would be?
I don't think we've gone to that level of detail at all yet. No.
Okay. And when do you anticipate the company would complete, I don't know the details of the study. It sounds like you had done recently. When do you anticipate the company would complete a study kind of the components and compatibility system-wide to understand the potential for large scale blending?
That one I'll have to have Mr. Gardner answer that one. He's directly into that kind of work.
He's the infrastructure guy, right?
Yeah.
Okay. So questions about what happens if it's incompatible, also Mr. Gardner.
That's right.
Okay.
Yeah.
Okay. I'll put those on his list. Just a question kind of as it relates to the modeling for you. It might be helpful for you to look at this. So Ms. Federico, maybe you could pull up hearing exhibit 1306. Hearing exhibit 1306 is an interim decision that the commission put out in this proceeding, largely when we were dealing with the controversy early in the proceeding about the use of offsets and CNG and those sorts of things. Okay, so we can go to page 26. Here the commission addresses kind of the differentiation between what we call enumerated clean heat resources. And when I say enumerated, I mean those that were specifically identified in the statute, in the clean heat statute, versus say other potential resources. And I think you went over with a previous council that blue hydrogen is not identified in the statute as a clean heat resource. Would you agree with that?
Yeah, the blue, it wasn't called out specifically.
Okay. So within this, I'll just go down, it's like the 8th line from the bottom on this page or something, and kind of get to the punchline here. it's, yeah, roughly 8 lines from the bottom. Read in concert, the legislature contemplated that clean heat resources get counted first and their use maximized before the commission considers other non-enumerated options, of which, I think we understand blue hydrogen would be one. So it kind of in relationship to this, it's my understanding that, and I know you're not the model expert, but it's my understanding that hydrogen is modeled kind of both blue and green with their presumed cost. To your understanding, was there any restriction in the model that would enact this commission directive that enumerated clean heat resources essentially be maximized and chosen before we go to non-enumerated resources and selection?
So I
ask me
don't
for
know.
clarification. I went on a long
Great.
time. So,
You know, I don't know if the model limited things per what you're describing. The model did limit the percent of hydrogen available to that 1% and 4%. But it didn't do it because of this. It did it more so because of the overarching plan that we had for blue and green hydrogen.
Okay. And kind of objectively speaking, the blue hydrogen is generally cheaper than the green hydrogen, right? In the model.
In the model, that's right, and we think that's the case for like the early days, early on, kind of the as this hydrogen industry is growing. We think that the blue would be cheaper.
Okay. Okay. So I'm just trying to sort through. We have the model somewhat indiscriminately picking. Like you have these concentration limits, and we have the cost factor, but I'm hearing, which was my assumption, it doesn't sound like there's anything in the model to trigger it to more or less enact what the commission had ruled here in terms of first maximizing the enumerated clean heat resources.
Yeah, I hate to punt like that, but I think that's a Dan Oz question. I don't know if the model did that or not. I only know that we said this is the hydrogen availability is limited to these numbers.
Okay. Thank you. Those are my only questions, Mr. Roselli. I'll go back to you.
Well, thank you. Oh, pardon. Thank you, Chair Gilman. Let's start with where we began there at the end with the questions from Chair Gilman. And this question of system compatibility, infrastructure compatibility with hydrogen. Okay, Mr. Jensen?
Yep.
And I know Chair Gilman asked you specifically about Rule 4553, but I want to ask about another rule. Doesn't matter what it is, but I'll tell you it's 4731E1. I don't expect you to necessarily recall what that is, but are you aware that there's a rule that essentially says before the company brings hydrogen to a given area of its system, it's supposed to provide that same kind of detail about materials and system compatibility specific to that system area?
Yeah, I'm generally aware of that.
Let's focus first on the various prongs of this blending demonstration project. And let's talk about the company facility blending proposal that the company brought forward in rebuttal, and then the commercial customer blending proposal that the company brought forward. The company would do that work and provide that information about the compatibility of those specific system areas with hydrogen once they've identified those specific system areas, right?
Yeah, absolutely. And that's a key part of exactly where we inject the hydrogen in whatever area or customer or facility we're talking about.
Now, would you do that even if there were no rule requiring you to do that?
Yes.
Why?
From an engineer's perspective, that's proper engineering design to consider all of the aspects of compatibility with the equipment you're using, and also it's also an important part in terms of the safety and operations of the system.
I want to go, we've had some discussion on blue and green. So I think we've had placed in our box, Ms. Federico, something that was marked as hearing exhibit 141. We'll see if that proves true. I'm hoping it's the clean heat statute itself. If you can pull that up.
I don't see anything labeled 141.
What?
I
So wait a
see,
minute. Do you see a clean heat statute?
I don't.
Okay, we'll come back to that then. Bypass that for now. And let's go back to the questions Mr. Dennison was asking you at the outset of your cross-examination. Do you recall that, Mr. Jensen?
Yes.
So there were a lot of questions that were posed to you in the sense of that demonstration project, not providing necessarily any specificity about which aspect of the company's hydrogen blending proposal we were focusing on. Do you remember that?
I do.
Okay, so I want to pull that apart. The company in this rebuttal case has proposed to do two different things that weren't in its direct case on hydrogen blending demonstration, correct?
That's correct.
Can you describe what those two things are, please?
Yeah, the first is utilizing some company facilities that are used to test various gas components, training, testing, things like that, and blend hydrogen, test blending of hydrogen there, being able to then test it with appliances or other equipment that the company uses. So that was the one part of using a company facility. And then the other part was identifying a single commercial industrial customer that wanted to blend hydrogen for their own decarbonization efforts so that we could work with them together and to develop in detail a blending demonstration project.
Okay, and the company's seeking approval now to proceed with both of those, correct?
That's correct.
And we discussed, and I think Mr. Dennison discussed with you, that the company's modeling does show the potential for hydrogen coming online beginning in 2027, right?
Yep.
But if the company receives permission to go ahead with these two new facets of demonstrating blended hydrogen on its system, those components could well be completed by the time we get to 2027, right?
Sure. Yeah, I think so.
The company does not yet know if it does in fact bring hydrogen to the system outside of a blending demonstration context in 2027. You don't yet know where that will be, right?
No, we do not.
It could be commercial customers.
Correct.
Or focus on commercial customers.
Mm-hmm. Mm-hmm.
And the commercial blending aspect of your proposed demonstration project, might that be complete at that time?
Yeah, absolutely. I think it could.
If the company does proceed ultimately with the residential blending project after the check-in in 2026, it might not be completed by 2027. I think Mr. Dennison asked you that question, right?
Yes, he did.
But it would be well underway.
I think so. Yeah.
You would have some results to look at.
Mm-hmm. And that original hydrogen, the residential hydrogen blending demonstration project was phased with different set points of blending as well as report outs and check-ins and things like that. That's an inherent part of the project.
Did you essentially state in your testimony that some kind of hydrogen blending demonstration project seems like an important and appropriate first step to using hydrogen?
Yes, I did.
Did you in your testimony state that it's an absolute prerequisite to complete a blending demonstration project before you deploy it outside of a demonstration context?
I think that's very important.
That's what you said?
Yes, I think so.
Mr. Dennison asked you some questions too about source and cost for green hydrogen. Do you recall those questions?
Yep.
Is Colorado the only potential source for green hydrogen?
No.
In fact, can you go into a little more depth on what you discussed on the Heartland Hub?
So the Heartland Hydrogen Hub, as we had in our application, is producing significant amounts of green hydrogen in our application, I think we call out around 400 plus tons per day of hydrogen, of green hydrogen produced from clean energy resources, wind, solar, and our nuclear assets.
It's possible that green hydrogen might be sourced in Colorado by 2027.
I think it is, yes.
It's possible the company could bring in green hydrogen from elsewhere if it's not sourced in Colorado by 2027.
Yep, that's, I think, a possibility as well.
Mr. Dennison asked you if you had specific cost information about what that green hydrogen would cost come 2027. Do you remember that?
Yes.
And I think you answered him that you don't have specific costs today. Is that fair?
That's fair.
But can you describe what cost information the company did provide in furtherance of the modeling process here in terms of levelized cost of hydrogen?
So both through our Hydrogen Hub applications as well as our development work, we have levelized costs of green hydrogen that include CapEx and a number of other things, and the production tax credit, things like that, looking out several years type of thing like that. So we have techno-economic analysis, TEAs, to provide those levelized costs.
So you did provide a cost of hydrogen for E3's modeling?
Yes, yes. We provided levelized costs of hydrogen for both the blue and the green hydrogen to E3.
There was a few documents put up in front of you. One of them was admitted into evidence that talked generally about blend percentages, 5%. Do you remember that?
Yes, the one that Mr. Broso shared.
Yes, that's the one. Yes. I want you to talk a little bit about your testimony and some of the reports you referenced that discuss blending up to 20% and what was observed.
So there's a blurb in my rebuttal referencing I think it's NEES report where there was blending of up to 20%, as well as the UK high deploy project that we did briefly talk about in one of the cross, and it's one of my attachments, where in a small community of roughly 660 I'll say customers that included residential, a church, a school, where they blended up to 20% hydrogen as well, and both of those studies reported no issues.
Well, when you say no issues with regard to what specifically?
With regard to I believe it was with regard to the operation of the appliances.
Any reported safety issues or concerns that you're aware of in either of those studies?
They did not report any safety or concerns. No safety issues or concerns.
Any negative impact on infrastructure or materials that were noted in either of those studies?
No, I don't believe so.
And that was hydrogen blended at a 20% blend, correct?
Correct.
Fair to say there's lots of studies out there in hydrogen, right?
There are a lot out there. Yeah, that's correct.
Lots of interest in this topic.
Yes.
And fair to say, different studies have reached different conclusions on these issues of blend percentages and interaction with appliances and infrastructure.
Yes, it is a space where there is a lot of work happening, a lot of information sort of streaming in as we're all trying to learn more and understand how to use it in its best way.
At the very end of that examination, I believe it was that examination, but it might be misplacing it. You were asked a question as to whether you think it's appropriate for the commission to consider all of this evidence, all of these other studies, for the good or the bad, regardless of what your perspective may be on these issues. Would you agree it's appropriate for the commission to consider all of that information?
Yes, I would agree with that.
Now I'm going to try to go back to our box and see if either hearing exhibit 1401 or something marked Senate bill has appeared. Ms. Federico.
I think you meant 141, right?
Probably did. What did I say?
1401.
Well, I'm changing my advocacy hat and defecting to represent. No, I'm not. Thank you.
There is a 141. I've got it. Just give me a second.
Thank you very much. And when you bring it up, I'd like to go to page 12. Or alternatively, I'd say if you have the ability while you're displaying, you could search for the word blue for us and we'll find it and it'll take us right there. Okay. So I'll represent to you that this is the clean heat statute. You can see it depicted there on the bottom, Senate Bill 21-264. I just want to make sure our record's clear on this because I think you initially answered a question suggesting that you had agreed or taken the position that blue hydrogen is an enumerated clean heat resource. It's not an enumerated clean heat resource, is it?
From that last question, no, I believe it was not an enumerated resource.
But the statute does talk about blue hydrogen, right?
Correct.
And the statute does allow for other tools and resources to be denominated as clean heat resources, correct?
That's correct too, yeah.
Well, Commissioner, or I should say Chair Gilman, I don't have any further questions. Thank you, Mr. Jensen.
Thank you.
Thank you for your testimony, Mr. Jensen. You are free to go, sir. You're excused.
Thank you very much. Appreciate it.
Yeah. I think we'll get Mr. Gardner started if you all can get him available. Tracy, I wanted to check in with you real quick. I was thinking we could probably get through 2 crosses or so of Mr. Gardner. Might not put us exactly at 5. We might be, 10 minutes or so after that. Are you available, Tracy, or no?
I am, Commissioner Gilman.
Okay, great. I will just, whenever it gets to 5, we'll finish that cross if that works for everybody.
Commissioner, just letting you know, I have a hard stop about 5:20, but if you're still going at 5:20, Stephanie can take over.
I'm not showing it'll take that long, so it is my hard bet. We'll stop before that. I think it's looking 5:10, 5:15 if people stick to their time frame. So thank you for letting me know and for working that out. Okay, Mr. Gardner, hello. Good afternoon.
Good afternoon. Can you hear me okay?
I can hear you fine. Thank you. Okay, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I sure do.
And are you alone right now as you testify?
I sure am.
Is anyone communicating with you in any way?
They are not.
If that changes during your testimony, will you please stop and let me know?
Absolutely.
All right, Mr. Roselli is available.
Thank you. Good afternoon, Mr. Gardner.
Good afternoon.
Would you please again state and spell your name for the record?
Yes, Ray Gardner, RayGardner.
And by whom are you employed?
Public Service Company of Colorado.
What is your job?
I'm Area Vice President of Gas Engineering.
And you filed 3 testimonies in this proceeding, is that correct?
That is correct.
The hearing exhibit 109, which was your direct testimony?
Correct.
Hearing exhibit 111, which was your supplemental direct testimony?
Correct.
And hearing exhibit 123, which was your rebuttal testimony?
Correct.
And those have been admitted into the record. Have you filed any, I'm getting some feedback. I know somebody else has an open mic, but
it looks like it came from Mr. Gardner. He lit up in the yellow, so maybe we're getting a little through you, Mr. Gardner. If you're not talking, maybe try mute and we'll see if that's off there.
Okay. Thank you, Chair Gilman. I was about to ask about corrections to your testimony, and I believe you made a correction to your supplemental direct testimony. Is that correct?
That is correct.
Okay. And that should be marked and in our box as hearing exhibit 111 Rev 1. If we could pull that up, please. And there you see that it's identified as hearing exhibit 111 revision 1, correct?
Correct.
And I believe the correction you made was that your original direct testimony spoke to the model selecting green hydrogen in 2027, and you corrected that to just say hydrogen in 2027. Is that correct?
That's correct.
With that, I'd move the admission of hearing exhibit 111, Rev 1.
Any objections? Right, so admitted.
Okay, thank you. With that, Mr. Gardner is available for cross-examination.
Excellent, thank you. First up, I have PUC staff for 20 minutes.
Thank you, Commissioner. And can everyone hear me okay?
Yes.
Thank you. Good afternoon, Mr. Gardner.
Good afternoon.
My name is Josh Foreman, and I represent the PUC trial staff in this proceeding. I'm going to ask you a few questions about the company's proposal for advanced mobile leak detection, which I'm going to refer to as AMLD. Is that okay?
Yep, sounds good.
And before I do that, I have a couple questions about your background. And as Mr. Roselli just stated, your current job title is Area VP of Gas Engineering. Is that right?
That is correct.
And before you became Area VP, you were a director of the Gas Integrity Management Program at the company?
Yes.
How long did you hold that role for?
Approximately 7 years.
And in that role as a director, did you become familiar with federal and state regulations regarding gas transmission and distribution integrity programs?
Yes.
In your current role as Area VP, you still possess a general working knowledge of federal and state gas regulations?
Yes.
Would it be fair to say that you became familiar with the clean heat statute for this proceeding?
Generally speaking at a high level, so not in detail though.
And turning to the company's proposals, are you familiar with the company's flex plan?
Very, very high level, but not in detail. I'm certainly not the witness for that.
Is the company's proposed AMLD initiative part of the market transformation portfolio?
Yes, it is.
And the market transformation portfolio is separate from the flex plan, correct?
That is my understanding, yes.
In your rebuttal testimony, you note that Senate Bill 21-108 directs the commission to develop rules that address the use of advanced leak detection technology. Are you generally aware of the rulemaking associated with Senate Bill 21-108?
I guess a couple things. First, I would say it's probably best when we're referencing my testimony to go ahead and pull it up. And then secondly, I believe that there's proposed rules out there that are not finalized to date.
Okay, well, we can pull up hearing exhibit 123, please. And page 5. And if we could scroll down a little bit to line 10, do you see your reference to Senate Bill 21-108?
Yes, I do. Thank you.
Okay, so you'd agree with me that you're somewhat familiar with the rulemaking associated here.
Somewhat familiar, yes. I think that the lines 14 and 15 go further to say that, in its rulemaking to implement Senate Bill 21-108, which is not yet concluded at the time of my testimony. So.
And thank you for that. You actually answered my next question. So I'm going to move on to ask if you're generally aware of the ongoing federal rulemaking on advanced leak detection that's currently in front of the Pipeline and Hazardous Materials Safety Administration, known as PHMSA, and for a court reporter's sake, that is PHMSA.
Yeah, yes, I am familiar.
And you'd agree that the PHMSA rulemaking has not yet concluded either?
That is correct, yes.
And we can take this exhibit down. Thank you. Is it fair to say that these rulemaking proceedings will help define advanced leak detection?
To some extent, yes.
In your rebuttal testimony, actually, I'm going to have you, Casey, could you pull up hearing exhibit 123 again, please? On page 6, please. Okay, Mr. Gardner, you acknowledge the company is subject to reporting requirements regarding advanced leak detection as part of its gas infrastructure plan, correct?
Which lines are you looking at?
Yes, I am looking at starting on line 6 through line 8.
Yes. Thank you.
Are you aware that the commission could approve the AMLD initiative as part of a gas infrastructure plan?
I think I'm aware that there are many places the commission potentially could. I think, we felt like that AMLD reduces methane emissions, which is also the objective of the Clean Heat Plan, which is why we felt it was fitting in this proceeding.
Okay, and going back to the, and thank you for putting this exhibit up, that you can take that down now. Thank you. Going back to the market transformation portfolio, you previously agreed that the AMLD initiative is part of the market transformation portfolio, correct?
Yes.
And you agreed with me that the market transformation portfolio is separate from the flex plan?
Yes, that's my understanding.
Would you agree with me then that the market transformation portfolio is not required under the Clean Heat Plan statute?
I couldn't make a judgment call on that. I'm not that familiar with the statute, sorry.
Can we pull up hearing exhibit 101, please? Can we go to page 93? And if you could scroll down to line 7, Mr. Gardner, could you please read lines 7 through 10 and let me know when you're finished?
I'm finished, thank you.
I'm going to represent to you that this is Mr. Eiley's testimony. Do you have any reason to disagree with Mr. Eiley's testimony here?
No, I do not.
Thank you. And you can take this exhibit down. Mr. Gardner, do you remember stating that AMLD is consistent with emission reduction goals? I believe you just said that.
Correct, yes.
But would you agree with me that the company's AMLD initiative does not count towards the Clean Heat Plan emissions target?
Objection. Objection calls for a legal conclusion.
Commissioner, may I respond?
Yes.
The witness is sophisticated on his experience in gas systems. He's also cited the statute in his testimony. I believe he is qualified to answer this as a non-attorney.
Well, if I could respond, you're asking, the counsel is asking the witness expressly whether it counts. Counts sounds like a very legal conclusion to me.
With the caveat, you're not asking him for a legal opinion, and to the extent he understands or knows, I'll allow it.
Mr. Gardner, would you like me to restate that question?
Yeah, if you could restate the question, that'd be great. Thank you.
Is it your understanding that the market transformation portfolio initiatives count or do not count towards the Clean Heat Plan emission targets?
It is my understanding, and I'm certainly not a regulatory witness here. Mr. Eiley would be much better to speak to that than I, but it's my understanding that emissions reductions as a result of the AMLD initiative that is proposed in the market transformation initiative would not count towards the clean heat. So.
Okay, so if you were to answer, if you could just Never mind. I'm going to move on to my next question. Are you generally aware that the company is asking for extraordinary cost recovery through two riders in this proceeding?
I'm going to object to that question as argumentative and beyond the scope of this witness's testimony.
May I respond?
I think it's fair that he asked what cost recovery is being requested. If he's aware, he can answer. If he's not aware, he can respond that.
Could you please restate the question?
Yes. Mr. Gardner, are you generally aware that the company is asking for extraordinary cost recovery through two riders in this proceeding?
I would say I'm generally aware that the company is seeking cost recovery through a rider.
If the level of advanced leak detection in your program became commonplace or became required by any new regulations, would those costs still be recovered in the rider, or should those transfer to more conventional rate recovery?
That I'm definitely not a rate recovery witness here, so I don't think I could answer that.
As the VP of Gas Engineering, do you think AMLD is something the company ought to be doing in its ordinary course of business?
I think that again goes to a recovery question, not a, my answer. I think, so I don't think I can actually answer that.
Mr. Gardner, are you aware the commission could approve cost recovery for AMLD in a general rate case?
Yeah, I think they could.
If I could just have one moment. Thank you for your time, Mr. Gardner. Commissioners, I have no further questions.
Thank you. City of Boulder, got you for 30.
Good afternoon, Mr. Gardner.
Good afternoon.
My name is Veronique Van Giem, and I'll be asking you some questions on behalf of the City of Boulder. We'll kind of start with talking about your rebuttal testimony generally. So in your rebuttal testimony, you talk about hydrogen blending demonstration projects in both a non-customer environment at the company's demonstration facility and in a real customer interaction context, correct?
That is correct, yes.
And the primary purpose of conducting the demonstration is for the company to get its own operational experience with hydrogen blending. Is that right?
There's multiple aspects of it, but yes, that is certainly a piece of it.
And has the company sought sources of funding other than through this clean heat plan for this type of demonstration?
Not that I'm aware of, no.
In your testimony, you mentioned that the second demonstration initiative involving blended hydrogen will be performed through providing one or more of your interested commercial customers, correct?
Yes, that is correct.
Can you clarify this testimony by identifying the customers, or at least types of customers, who have expressed interest to experiment with blended hydrogen in their facilities?
I think that's really the point of doing an RFI process is to identify those customers. So I don't think I can give you a characterization of exactly which customers that would be. I think, and actually, I think in reality, I think there's signs that there are customers that are likely interested in this type of behavior. And I think your own witness, Carolyn Elam, actually cited that with Amazon running hydrogen-powered forklifts. So I think that's a clear sign that there's interest, but we haven't done an RFI yet, so we wouldn't be able to know yet.
Thank you. So we had some questions for your colleague, Mr. Jensen, that he referred to you, and it related to safety as a core value at Excel Energy. You also talk about safety in your rebuttal testimony, where you recognize that it's a paramount consideration for the hydrogen blending demonstration project, and that you are working on safety protocols correct?
Yes, that is accurate.
So Mr. Jensen stated that the company's expertise in safe handling and operation of natural gas systems will readily apply to natural gas blended with hydrogen. Do you agree with that?
Yes, yes, I do.
And you agree that hydrogen is a smaller molecule than methane?
Yes, I do.
Would you agree that hydrogen embrittlement is generally defined as mechanical damage caused by hydrogen penetrating into a material and reacting with that material?
No, I don't think that actually lines up with the ASME definition, which is a loss of ductility due to absorption of hydrogen. It's a little bit of a different deviation there.
How is it different?
Well, I think by word you can put those pieces together, because I think you've got information in your definition about reacting with it. I'm not super familiar with your definition. I'm familiar with the ASME standards.
Okay. Would you agree that steel and aluminum alloy are among the materials most susceptible to hydrogen embrittlement?
Not as a blanket statement. I think when you look at the susceptibility to embrittlement, I think the ASME code makes it pretty clear that the susceptibility of steel to hydrogen embrittlement is subject to what's called a stress intensity factor. I'm not sure if you're familiar with that, delta K, as well as the actual pressure, partial pressure of the hydrogen. So specifically, the ASME standard talks about wall stresses that are in excess of 30 to 50% of the specified minimum yield strength, looking at the wall stress. And specifically looking at high strength steels.
Okay, but under some conditions, they are susceptible to hydrogen embrittlement.
They could be under certain conditions, certainly.
A customer could be served by polyethylene pipeline to the gas meter, but then have steel gas lines on their side of the meter. Would that be correct?
By building code, they could have corrugated stainless steel, or they could have black steel.
Thank you. Are you familiar with how the company inspects the mechanical properties of its pipelines?
Yes, I am.
Can you describe that?
Which pipelines are you referring to?
Guess they're the pipelines that you plan to use for the demonstration project.
Well, it's an interesting question you bring up, because I think what we're proposing is a demonstration project to customer, or on not in a residential blending at this point. What we're proposing is company facility and then a commercial customer. And so the commercial customer side, it very much depends on exactly who the commercial customer is. And then on company facilities, we'd be looking at polyethylene pipe. So maybe if you can expand your question a little bit more as to exactly what pipe you're looking at that you're interested in understanding about.
Sure. On the residential side, just generally on you talk, well, let's start over. So you talk a little bit about how 64 to 70% of the pipeline is polyethylene pipeline in the distribution system, and then I'm assuming the other 30% is something else. So for an example on how you inspect those different kinds of pipelines, can we look at the pipeline in downtown Boulder?
I don't think I could give you just committed to memory exactly what types of pipe are specifically in downtown Boulder, just off the cuff. I don't have that committed to memory, sorry.
That's fine. Some utilities use cameras that can be run down pipelines, sometimes referred to as pigs. Do you know if this is a tool the company uses?
I'm definitely familiar with pigs and inline inspection devices, yes.
Do you know if that's a tool the company uses in inspections?
Yes, it is. Yes, it is a tool that the company uses.
Okay, thank you. We're moving on a little bit. To further in your rebuttal testimony, you talk about concerns with embrittlement of the steel pipeline over time are mislaid with regard to the hydrogen blending demonstration project because the project area was served by polyethylene pipeline. Is that right?
Yes, that is accurate.
And a project that exclusively uses the best case material, for example, polyethylene pipeline, would not be representative of a system-wide deployment of blended hydrogen, correct?
Possibly, but I don't think we're proposing a system-wide deployment of hydrogen. So,
right.
And I think when we laid out the goals of the demonstration project, I don't think we implied that the material compatibility specifically was one of our objectives there. I mean, there's verification, but we wouldn't want to inject hydrogen if we didn't feel comfortable with the material compatibility before we started.
But it's not representative of system-wide deployment. That's why you make that distinction, right? That it's not being deployed system-wide.
Yeah, I mean, I think it's fair to make the statement that when you look at our system, just like you just mentioned, that between 60 and 70% of our system is polyethylene pipe. So saying that a system that is 100% polyethylene would not be exactly reflective of our entire system is a fair statement.
Right. So would you agree that gas meters are typically constructed of steel and cast aluminum?
So gas meters are constructed of steel, but I would come back to exactly where I went when we started this about understanding delta K and understanding the stress intensity factor. So do you understand the partial pressures that our customers actually receive?
Well, I think I'm the person who's asking the questions. So has the company considered that the delta K of steel and cast aluminum gas meters when considering the deployment of the demonstration project?
Yeah, absolutely. I'll answer my own question for you, and that the delivery pressure of a gas meter is approximately a quarter pound of PSI. And I think I mentioned the embrittlement factors being a consideration at 30 to 50% of yield strength.
Can you tell me what percentage of the public service gas transmission and distribution system utilizes steel pipeline?
I couldn't tell you that number. I don't have it committed to memory.
Okay.
Also, I'm not really sure that it's relevant since we're not proposing to blend hydrogen across our entire system or specifically on the transmission system.
Can you tell me how many disconnects were executed by the company during 2023 due to customers not paying their gas bills?
I wouldn't have that committed to memory.
Would you agree that when a customer is not using gas, there is a stagnant pressurized gas left in the line, which could increase the likelihood of embrittlement occurring?
No, I think that's only, I think you're just taking one factor in isolation. And as I mentioned before, there's a lot of industry standards that involve hydrogen embrittlement. I think you're mischaracterizing how that actually occurs.
Can you describe a little bit more about how it does occur?
I'm not really understanding the root of your question here. I mean, I think when you say a customer stops utilizing gas, that there's gas sitting at a pressure, but the reality is that when the system's in operation, it's operating at that pressure regardless of whether the customer is receiving gas at that moment or not.
So when they're not using gas, the gas is not stagnant for extended periods of time?
Well, I think I'm not really even understanding your question, because I think you're proposing a hypothetical here that just doesn't really make sense to me.
Okay. When a customer is disconnected, the company does not go and disconnect the service line and remove the gas meter. Is that right?
When a when a customer is disconnected?
Yes, from this, from service.
Well, that would certainly depend on why they were disconnected.
We can move on from this part here. The study, one last question on this part of your testimony, part of your and Mr. Jensen's testimony. The studies referenced by you and Mr. Jensen did not investigate hydrogen embrittlement of service pipeline and or gas meters due to extended exposure of pressurized hydrogen blends that sit stagnant in those lines for extended periods of time, correct? So just for clarifications, and we're asking about the amount of time that the tests were done or the models that you reference in your testimony. Those studies were done over shorter periods of time, correct? 18 months, a few years.
That was a very long question. Can you restate?
Yes.
Struggling to follow.
So to clarify, so the studies referenced by you and Mr. Jensen did not investigate exposure of pressurized hydrogen blends that sit stagnant in those lines for extended periods of time.
I don't think that's actually a fair characterization, because I think when NREL has done their studies, they have looked at time duration of hydrogen exposure when they're looking at the impacts to both metals and polymers as part of the Highland study.
Okay. So let's move on to your testimony about the Angeles Link project. You cite that as evidence to support the company's proposed hydrogen blending projects, correct?
I definitely reference it in my testimony as being a evidence that there is a lot of interest in hydrogen.
And that project is a feasibility study on using a dedicated transmission pipeline to transport clean renewable hydrogen to the Los Angeles basin, right?
So I'm not 100%, I'm not entirely intimately familiar with all of the details of that project. So if you're referencing something, it's probably worth bringing up, but I'm familiar in concept that it's a transmission pipeline bringing hydrogen to an area.
And would you know what % of customers who currently take gas commodity service from public service are served by a dedicated transmission pipeline?
I wouldn't have something like that committed to memory.
Would you agree that a targeted outcome from the Angeles Link project is to displace diesel fuel use in heavy duty trucks?
That was certainly one of their objectives, yes.
And heavy duty trucks are a use public service considers hard to electrify, correct?
Can you provide a reference for how you're making that assertion?
I was just speaking to your testimony generally around these issues.
Yeah, I mean,
but if you don't know the answer, you can just say no.
I mean, can you restate the question? Maybe we start there.
So does public service consider heavy duty trucks a hard to electrify?
I don't think I can necessarily make that assertion. I mean, I think we can all agree that a heavy duty truck that's electric, I mean, there's certainly development in that area, but I think they still have a ways to go. I think that's a fair statement.
And would you agree that heavy duty trucks is an application that public service believes could be served by natural gas blended with hydrogen?
I don't think we've made that statement anywhere.
Okay. Would garbage trucks be an example of a heavy duty truck that the company would consider hard to electrify?
I also don't think we've made that statement anywhere either.
Okay. But public service has program offerings and pilots targeted to medium and heavy duty fleet electrification, correct?
For electrification or for?
Yeah.
I'm not intimately familiar with all of our electrification initiatives.
Okay. Well, that is all my questions. Thank you.
Very timely, Miss Spangy. So for all my concerns about going after 5, we do have a few scheduling conflicts, so this is good. We can wrap up right before 5. I did just want, so Mr. Gardner, you are going to be back on in the morning. So we'll resume with you on the stand at 9 a.m. tomorrow. I did just want to recognize, it's my understanding that Denver is getting a snowstorm. And I understand that sometimes snowstorms can be scary in Denver. But it is my understanding from our team that we are prepared, willing, and planning to staff this tomorrow, even in the event that there is a snow day or whatever you call it when you're grown-ups and they shut things down for snow. So I did just want to notify folks of that, especially given the commission's schedule and calendar. I think it would be incredibly difficult to reschedule. So please do let me or let Ms. Dundas know if you have any major complications tomorrow. But I did want to notify you before we got any sort of official word of anything. Even in that case, we're planning on doing this tomorrow. So
Commissioner Gilman,
major problems. Yeah.
I had one thing I wanted to let you know. I am not going to have any questions for Dr. Bilsback. And I think that I was the only one. So she's off
all right. Let's not let Dr. Bilsback off the hook just yet, because I was intrigued by you retaining. So we'll see. That would be a Friday situation, so we can still figure that out tomorrow, because my understanding is that witness would like to go Friday. So it's not happening tomorrow anyway. Other than that, I don't want to hold us too long. I know there were a few complications with 5 o'clock on our team. But regarding the snow day issue, I think that's clear, or lack of snow day issue. And y'all can go sledding when it's done.
So Chair Gilman, is the plan to commence again at 9 o'clock in the morning, absent some other communication?
That's correct, sir. Absent, I believe, unless you all have no power or something as a complication, which would be super ironic. And like, we just don't even want to go there.
I agree.
So, yes, absent some major issue, which would get some communication out from our team to you, we plan to resume at 9 a.m. tomorrow as planned. Mr. Gardner will still be on the stand.
Thank you.
I'll be here.
Excellent. Thank you. You can be anywhere. That's the beauty of it. If you need to stay home because of the snow, I'm not your employer, but as far as I'm concerned, you just need your camera on and your sound, ideally.
As long as you can send me a note, then I'm good.
Okay, excellent. With that, I think we will wrap today right on time. Ms. Colicchio, you have something you need to do before we leave today?
I did, Commissioner Gilman, and I apologize. I just wanted to give the parties enough notice of this witness availability change. Mr. Hay had a family matter come up and he will not be available on Friday, and was hoping that if he were to go Friday, we could move him to Monday. I just wanted to make everyone aware as soon as possible.
Let me look. I think sorry, when's he not available again? He's not available.
He's not available on Friday, Commissioner Gilman.
Okay. Okay. Friday had a lot of other demand, so I think we can work around it. I don't think there's any chance we'll get to him tomorrow. So it's looking like Monday in that case. So I'll address the schedule, get you guys any updates tomorrow with what I'm thinking for witness order. So hey, no Friday. Okay.
Thank you for that. Apologize.
Any restrictions Monday for him? Or
no.
Okay. 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 put him down for Monday, and I'll work on some of the details around that. Okay, perfect. I'll see you all at 9 a.m. tomorrow. Thanks so much.
Thank you.